petition GM branch. Before A group before A group first list B group and 19th second list. ಆಗತ್ತೆ ಅಂತ ನಿಮ್ಗೆ ಹೇಳಿದೆ ಅಂತ ಅನ್ಸುತ್ತೆ. 395 ಇದು ಯಾವ ಕೇಸ್ ನಂಬರ್ 6 ಸ್ಟೇ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಿಮ್ಗೆ ಸಿಕ್ಕಿಲ್ಲ. ಇದು 391 6 ಅಂತ ಬರ್ತದೆ. CP first matter. Give your memos.
Today at 2:30, my lord.
Just wait, later other memos. Yes.
Today at 2:30, my lord. Election is scheduled to be held on tomorrow, my lord.
2:30. Election. List 1, page number 1.
May it please your lordships. This is
Yes.
Advocate Nedumbar, my lord. I'm sorry to trouble your lordships. There's a matter, my lord, which has been, the court has, the matter which has been disturbed a couple of times. One way or other, it couldn't be finally heard or disposed of. This is concerning recovery by the cooperative banks through the mechanism of the state cooperative society, the cooperative laws. Whereas the banking is a central subject and the laws enacted by the parliament hold
No,
exclusively.
you move a memo, we'll list it. You move a memo.
My lord, I'm in Bombay, my lords. My lord,
Move,
my
move
lords,
online is there. You have to move you have to move a memo to your associate here, we'll consider it.
No, my lord, I will move that, but your lordship may give me a date. That's only a formality of giving a memo. My lord, your lordship sir alone can give a date. I'll come
Yes.
to Bangalore a particular date which your lordship is pleased to grant. Keep any date of
Yes,
your
you
lordship.
move, yes, you move a memo, date will be assigned in advance.
Yes. And could it be sometime
That
next week
matter
at
is
2:30,
listed on
2:30,
16th.
2:30 any of these days? 2:30 my lords, because I'll come specifically for that.
Let
Okay,
us see.
many times.
Yes, I'll consider. Let us see.
That will be specific, my lord.
Let us see. Let us see. You please
Any
move the
date,
memo.
any your lordship could
Yes.
indicate
You
some
move
dates.
the memo. Yes, you move the memo. I'll have the date and
Could
see.
it be on next Tuesday? Could it
Let
be
us
on
see.
next?
Please move the memo. We'll see.
Yes. Greatly obliged. Greatly obliged.
Adjournments, list 1, page number 1, 1 to 7. Page number 2, 8 to 12. Page number 4, 13 to 17. Page number 5, 18.
My lord, serial number 18. Senior is out of town.
You appear for,
Respondent number 8.
have you informed the petitioners? You wait, when it reaches, I'll accommodate.
Okay.
Let it reach.
Page number 6, 19 to 21. Page number 7,
Serial number 21.
21.
21. 21.21 petitioner on the other side's informed.
Let us see, it's a batch matter, when it reaches, I'll accommodate.
Page number 7, 22 and 23. Page number 8,
Serial number 23, my lord.
23.
The batch of matters of 23, 23 point until like that. We are for appellant in the main matter, connected matter. Respondent is here.
The connected
Kindly.
matter, I am in the impleading respondent, I am there. First matter, your lordship. and
No, let us see
subsequent-
these connected, yes.
Subsequent that those petitions, I am appearing in those petitions. In the first
Correct.
matter, I am for the respondent.
No, you want a time, is it?
Yes, my
Not
lord.
me,
Yes, my lord. I need.
they want time.
These all are batch connected.
Yes, please,
We'll have it next week.
please.
Yes, my lord.
Interim order may be extended, your lordship.
Relist the matter on interim order earlier granted is extended till the,
Interim order that is against the petitioner because they are taking a coercive step. So these respondents have sought for an interim that is granted. So time to time that is extended in this.
but get ready on the main, let us.
Yes, yes, we are ready.
Synopsis to be filed by both sides containing list of dates, summary of contentions and authorities relied upon by the next date. When do you want?
Any after next week.
Date?
12.
Well,
One more, there is one more petition which is not listed. That is WP 28486 of 23.
list WP so and so along with
28486
batch.
of 23.
Yes.
Obliged.
State is anybody who's a contesting respondent.
We are the
Not sent.
contesting response. We are the principal borrowers. And it is there, this is regarding that debt record, coffee board, those package regarding where they have given subsidy to that extent,
Let us,
please.
Page number 10, 24 to
Bless
23. Page number 11, 29.
My lords, 28, serial number 28. Seek adjournment. The senior counsel is keeping unwell, my lord.
28.
Seek grant of 2 weeks' time might be granted. The senior counsel has been advised to take rest.
2012 matter, why we should give time? What is the what is the reason? for-
My lords, senior counsel has been keeping unwell and he's been advised
Is
rest.
that a reason, madam?
My lords,
Is that a reason, madam? You can't give that reason. You give
my
some.
lords, the opposite counsel has been informed, my lords. If
That's
you,
of no relevance to me. 2012 matter, you can't take time like this.
my lords, the senior counsel is not keeping
Madam, when
well.
once the judge says you shouldn't repeat that, sir. I'll grant you time. But always when you're asking for time, you must give some other reason. On the next date, you should be ready.
2 weeks' time might be.
I'll give you a date. On that date, you'll have to be ready to go ahead with the matter. No further adjournment will be given.
Please,
Date
ma'am.
14.
14th.
Obliged.
No further adjournment. You have to get ready.
Please, well.
Both sides to file. Wait, both sides to file synopsis consisting of list of dates, summary of legal contentions and authorities relied upon. Such a synopsis to be filed with advance copy on the served on the counsel for the other side.
Please, my lords.
Number 11, 29. Page number 12, 30 to 34.
Serial number
33.
Serial number 30, my lord. Only 1 week time may be granted. my lord.
You have informed the other side.
I will inform.
You appear for,
Respondent number 2, my lord.
you have informed the petitioner.
Adjournment.
At request, release the matter.
Obliged. Serial number 31, my lord.
Yes,
Serial number 31, my lord.
31.
For the petitioner, I already informed the other side. my lord. So, week's
So-
time,
This is the matter next week at request.
interim order may be extended.
Interim order earlier grant is extended till the next date.
My lord, serial number 33, my lords. Here for the petitioner, kindly grant us a week's time, my lord.
At request, is the matter next week.
My lord, second list, serial number 29.
Just
Number two, adjournments, which one, page number 1, 1 to 7. Page number 2, 8 to 17, 3, 18 to 27.
Number 2, my lord, serial number 10, my lord.
Serial number,
Serial number 10, my lord.
which list?
List number 2, my lord. RP for the respondent,
CP number
240, my lord.
240.
I pray for some time to file my application.
Have you informed the petitioner? You have to inform and then report to the court officer. This is the matter next week at request made on behalf of the respondent. Inform the other side, otherwise when it reaches, we will accommodate.
Serial number 30,
13,
30.
just wait.
Page number 3, 18 to 27.
My lord, serial number 23.
Yes, at request. This is the matter next week.
Page number 4, 28 to 33.
Serial number 30.
Serial number?
For the petitioner. 30.
30,
We have no instruction, kindly, maybe matter settled. So kindly next, 2 weeks time.
Now I'll give a date next week, find out, check the website and find out. 30. Inform the other side.
7.
This is the matter on, so check. Madam.
Serial number 29, my lord.
Yes,
Here we are for respondent and it's for mediation, my lord. Mediation date is on 11th. So
This is
any
the
day after
matter.
11th.
week after next.
14. Page number 5, 34 to 40. Page number 6, 41. Which one, fresh matter, serial number 1. Vachan.
Appearing for the petitioner in this case. Appearing for the petitioner in this case, my lords. The petitioner's husband had obtained a loan from the.
No, correct. Now, what is there must be some alternative remedy. However, we directly come not one. 2, what can we do? It's unfortunate, that's all I can say. We can't help it. What is your legal right?
My lords, there is,
Use the mic, yes. What is your legal right and what is wrong with the order? That's all you have to tell me.
my lords, it's an unsecured loan, my lords.
So what?
My lords, this honorable court in an unreported judgment, it has held that the banks cannot sue the wife for the loans taken by the husband.
What is the legal logic? What is the legal logic? Wife is a legal representative of the husband.
Yes, my lords.
Then
My lords, I could not find the judgments, my lord, but
no, I'm saying what is wrong with this order? Husband has taken a loan.
yes,
He
my lord.
passed away.
Yes, my
Wife must repay it. What is
Ma-
the legal contention you're advancing? To say that there is something wrong with that exercise of power.
my lords, when the surety, wife is neither a surety nor a guarantor, my lord.
Not required. She is the legal representative of the husband.
Yeah,
Legal representative of the principal debtor.
yes, my lords, but no, it was not for the welfare of the family, my lords.
No, that all defense you can't take. She is after all the wife and she is the legal representative of the husband. There ends the matter. I find absolutely no reason for interference.
My lords, my pass a paper cutting, my lords, this,
Give me newspaper cuttings. You're a lawyer. I'm a judge. Can
Yes.
we look at media reports? Take
because,
out a legal case, I'll consider. I'll have it next week. Think about it. You come out with some legal argument. I'll see.
yes, ma'am.
On the face of it, I am not at all convinced. You make a legal argument, get authorities, let us see.
Please, ma'am.
When do you want? Next week?
2 days.
Date good. Relist the matter in the same stage.
6th,
Yes.
Obliged.
serial number 2.
Give for the petitioner, please. But the third respondent membership is
So
questioned.
now is there not an alternative remedy?
There is no alternative.
Why?
Lord, I have produced the rules of the KGA Association at Annexure B.
No, now admission of a member,
Yes, ma'am.
isn't it?
Yes.
Why you can't raise a dispute under 17?
Lord, I filed a dispute application before the registrar. Lord, registrar is not taking it seriously at annexure R, if my lord sees, page 74.
Page?
Page 74, my lord. The typed copy is at page 75. Lord, this is the order, please, my lord. This is the order sheet. Applicant present, association, advocate present and submitted wakalat. Wakalat has been accepted, requested time for objection, posted for inquiry on 29. The reason for urgency to be moved before this honorable court is, he is taken as member elect, please, my lord. His tenure for member elect will be 6 months, my lord, which may expire. And if they don't take any further action, either repealing his membership or accepting it, automatically they can consider his application for permanent membership. That is the reason I moved this honorable court. as
No,
an
no,
urgent.
the matter is stated tomorrow, isn't it?
Yes, ma'am.
Pass an order directing him to consider interim relief.
That also can be.
Now, where is that, you are saying that,
My lord,
Provisional-
kindly come to page 71, my lord, in page 71. This is annexure P, please, my lord. Last portion of annexure P. Briefing of Honorable Secretary, 4.6. Letter from Mr. B.R. Anand to deny membership to Arjun Anekar Devpal. The Honorary Secretary brought to the notice of MC that one more letter dated 28/8/23 has been received from Mr. B.R. Anand concerning Mr. Arjun Devpal membership application. To put on record, she read out the concluding portion of his letter. I draw your attention to Rule 26.1, which now becomes applicable, and states that if a member's conduct either inside or outside the club is injurious to the reputation of the club, action shall be taken. The Honorary Secretary informed the letter will be kept in the personal file of Mr. Arun Anekar, and MC is going on to go ahead. But this is not the proper action which the MC could have taken, please. In fact, earlier committee withheld and said we are not considering for the moment till Century Club has given a clearance.
what is the relief you have sought for in the dispute?
Lord,
Lord, before this honorable court, I have sought for.
I request one submission me. Lord, this matter pertains to Society Registration Act, my lord. The bench for holding the GMKSR, this is a cooperative society. That is one aspect.
No, so the separate roster of a society.
That is GM.
Manjana. GM society registration. Separate roster. Separate roster number. Societies, cooperative society. We'll pass over, we'll take it. We'll
Please.
pass over. We'll just.
GMKSR, brother.
No, let us pass over.
3. Sunday Street.
Appear for the petitioner's counsel.
Find out why it has not been held so far. Is the election, is it non-holding?
No, it's not that much. The number of members for the committee are 19 as per the amended bylaw which your lordships get at page 12.
Bylaw 36.
Bylaw number 22 amended bylaw, your lordships get at in page. Annexure A, page, it starts from 11, page 12 may kindly be seen. It's provided for 19 members, including the MD, who will not have a voting right in the election matters. Total 19 members. It appears against 3 members, there is some order of disqualification and some proceedings. Therefore, those 3 seats have remained. Presently, they are not under voting. Post became vacant because of resignation. Under the rules, it is the returning officer appointed by the department who would be conducting the election. Rule 14 AG.
Cooperative Society Mediation. ತಪ್ಪಾಗಿದೆ. ಮಾಡಿರೋ ಯಾವ್ದು ಅಂದ್ರೆ
Rule 14, capital A, capital G.
Yes.
Please. The returning officer appointed for conduct of general election of directors to the board shall be the returning officer for conduct of election of office bearers. Whenever a casual vacancy occurs in the office of the president, etc., my lord, the CEC shall take steps for conducting the election to fill up the casual vacancy in the office of president or vice president or any other office bearer as the case may be, and appoint returning officer for the purpose of conducting the election, that is Cooperative Election Authority to appoint the returning officer. The returning officer or the assistant returning officer appointed under sub-rule 1 or sub-rule 2 shall within 15 days from the date of commencement or deemed constitution, etc., convene a meeting of all the directors who are eligible to vote for electing the chairperson, president, vice chairperson, president, etc. Such other office bearers as are required to be elected under the bylaws of cooperative society. Meeting shall be convened by giving a notice of 7 clear days sent by registered post, personal delivery under acknowledgement indicating the date, time and venue of the meeting. Now kindly see rules, sub-rule 6, capital A. The quorum for a meeting of the board convened under sub-rule 6 shall be fixed at the number next to 50% of the strength of the board. Especially a provision for quorum is provided. Strength of the board is 19. Therefore, quorum would have been, because fraction is not allowed, so it would have been 10. For a moment, assuming 3 directors who have been disqualified, there is a vacancy. Your lordships, kindly see the strength of the board would be 16. A number more than half is the quorum. What the returning officer does is, my lord, kindly go to Annexure D, page.
50% of the strength of the board means total strength or existing strength.
That's why I said it should be total strength. But there, assuming for a moment the vacancies are to be left out for the purpose of counting, then also 16 remains. Quorum would be 9.
Half of?
One number more than half.
One
number more than half.
So 8 plus 1.
8 plus 1.
Yes.
Kindly see typed copy of Annexure D at page 24. Starts at 24. Kindly turn to 25. ಹಾಜರಿ 8, ಗೈರು ಹಾಜರಿ 5. ಸಂಘದ ಉಪನಿಯಮ ಸಂಖ್ಯೆ 22ರ ಅವಕಾಶದಂತೆ ಸಂಘದಲ್ಲಿ ಒಟ್ಟು 19 ಜನ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರುಗಳು ಇದ್ದು, ಇದಕ್ಕೆ ಶೇಕಡಾ 50ಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ಕೋರಂ ಎಂದಲ್ಲಿಯೂ 10 ಜನ ನಿರ್ದೇಶಕರಿಗೂ ಸಭೆಗೆ ಹಾಜರಾಗಿರಬೇಕಾಗಿರುತ್ತದೆ. ಆದರೆ ಈ ಸಭೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 14 ಜನ ಡೈರೆಕ್ಟರ್ಗಳಿಗೆ ಮಾತ್ರ ನೋಟಿಸ್ ಜಾರಿಗೊಳಿಸಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಭೆಯ ಕೋರಂ ಅನ್ನು 8 ಜನರು ಎಂದು ಭಾವಿಸುವ ಮೂಲಕ ಈ ದಿನದ ಸಭೆಯನ್ನು ಪ್ರಾರಂಭಿಸಲಾಗಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಸಹಾಯಕ ನಿಬಂಧಕರ ನ್ಯಾಯಾಲಯದಿಂದ ಒಬ್ಬ ನಿರ್ದೇಶಕರನ್ನು ಈ ಸಭೆಯಲ್ಲಿ ಹಾಜರಾಗದಂತೆ ತಡೆಯಾಜ್ಞೆ ನೀಡಿರುತ್ತಾರೆ. In the court proceedings, according to returning officer, he has received an order restraining one member from participating in this thing. Then what he says is, ಇವತ್ತಿನ ಇದಕ್ಕೆ 8 ಜನರನ್ನ I consider it as quorum for holding the meeting.
Let us see, you take out notice.
It is not for him to, first thing is, it was not for him to decide that
Lord,
without the quorum, this thing. And he says, yes, as per the number, there is no quorum, but I take it that in view of the stay order in respect of one member, I will proceed to hold that there is quorum. This is not something which
Lord, one thing in this matter, the question of that, the consisting quorum, what number, whether it is 19 or the existing, the board, that has to be
No,
settled.
even
That is
taking
not
that,
settled. If the my lord, the rule says that the quorum constitute which is specified in bylaw. Bylaw says that the 19 is the board strength. When board strength is 19, then 10 will be the quorum constitute according to the bylaw. So according to bylaw, the quorum says that there should be a 10 member. Here the case, my lord, the election to the president. The person who doesn't have confidence on their own member, he cannot say that this is the quorum or that is the quorum. That question arises here.
Let us see,
Oblige.
you take out notice.
it is not that question at all. For the meeting, there is quorum. Who gets elected is another aspect. Among the quorum, I may get the vote, I may not get the vote. That's altogether different. For conducting the meeting, there should be quorum. There cannot be a meeting without that quorum and proceeding with the election.
Transact the
It
business.
cannot be the proceeding at all. Quorum prescribed under Rule 6A of 14G is quorum for a meeting of the board convened under Sub-Rule 6 shall be fixed at the number next to 50% of the strength of the board. Therefore, I considered, assume for a moment, 3 members who are disqualified are to be kept out for the purpose of calculation. Still, 9 would be the quorum. And annexure E may kindly be seen. Ink page 27. Under the bylaw, last rule, bylaw number 636, ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯ ಕೋರಂ 9 ಆಗಿರತಕ್ಕದ್ದು.
This must be, now this governs.
Not,
Therefore,
no.
even otherwise, even taking the rule, all those things, even under the bylaw, it is minimum is fixed 9. Excluding or including all those things will not be of any this thing.
And unless the bylaw itself has been challenged,
Yes,
you can't raise it in collateral proceedings.
no. Therefore, my respectful submission is, even under the rules it is so. Here, that number 9 is the fixed as the quorum for the meeting under the bylaw itself. Therefore, this meeting, which admittedly he himself says it is 8, I will consider this as this thing on the ground that in respect of one member, there is an order of restraint or something. It's not for him to say he is not a member, all those things.
That is, AG accepts notice for respondents.
My lord,
1, 2,
1, 2, 4, my lord.
1, 2, 4.
And
1,
more
2
than
and
it.
4.
1, 2, 4.
Emergent notice to respondent 3 and 5. Petitioners at liberty to take out notice by way of hand summons as well to the respondent 3 and 5. Relist the matter.
Lord, they have to make a party to the cooperative election authority.
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಮಾಡಿದೆ, ಇದಕ್ಕೇನು ಅವ್ರು ಬೇಕಾಗ.
But specifically rule says that it is the duty of the election authority to conduct the election.
They have appointed a
To that
returning.
extent, he will be under the control of the cooperative election authority until he finishes the election, sum up, come with the result.
You can make him.
No difficulty to make, but it is not necessary. Kindly see 14 AG.
No, but now who decides regarding the quorum, etc.? I mean, now the order is passed by,
Returning officer has passed the order. He says, I will treat it as quorum and proceed to hold election is what he says.
Lord, everything will be communicated to election authority. He is the under control of the cooperative election authority until the election is completed.
anyhow, we can make him for whatever it's worth. Let us see later. Make him so that to avoid delay at that point of time. in
Then
case-
your lordship may kindly permit me to
But oral-
implead, and
oral-
Mr. Kiran Kumar, my
Oral-
learned friend, Mr. Kiran Kumar may be directed to take
oral
notice.
request is made for impleading the
Cooperative Election Authority
cooperative election authority.
as respondent number 6.
An additional respondent said the oral request is acceded to. Learned Counsel Kiran Kumar is directed to accept notice for the said respondent.
One of those things, except the power of the returning officer to do this.
It's a pure question of law.
Pure question of law. And tomorrow they have convened the meeting, my lord. The new committee with under the chairmanship of respondent for you.
We'll make it subject to orders to be passed. Let us see.
ಅದು ಹಾಗೆ ಮಾಡಿದ ಕೂಡಲೇ ಮತ್ತೆ interim prayer consider.
No,
Election
we'll
ಆಗ-
make it clear because now ex parte, it will be necessary that let's see, it'll have implications, but we'll consider it.
Lord may request,
May-
if quorum is not there in earlier meeting, my lord, the transaction will not be considered under law. They will again call a fresh meeting. If they succeed in showing that the majority, then it will be in their benefit, my lord.
It is needless to state any action taken pursuant to annexure
D.
D would be subject to orders to be passed. Let us see on the next date, we'll consider.
The consideration of interim prayer. may be kept.
ಅದು ಬರ್ದಿದ್ದೇವೆ. Consideration of interim prayer is kept open.
Serial number 4. Petitioner Lord.
Lord, annexure A, my lord, page number 10. Elections held on 4/2/2024. Results also is announced, my lord. So one of the elected member prepared this writ petition, my lord. After the elections, my lord, see annexure C, my lord. Annexure C, page number 14. Election date also is fixed for president and vice president, my lord. Meanwhile, my lord, state government has been nominated one of the nominated director, my lord. Page number annexure D, my lord. Page number 16. Annexure E is the interim order, my lord. This honorable court has been granted interim order, stay of the nominated director, my lord. After that, my lord, elections has been fixed on 18/2/2024. Page number 18, annexure F. F, my lord. See, I'll read annexure F, my lord. Annexure F.
No, now let notice go, we'll fix a date. We'll see.
No, my lord, as per 14, see intentions of the, I'll read this annexure F, my lord.
Section as per.
Section as per 14 AG, my lord.
uh,
3, my lord. The returning officer of the estate is returning of 14 AG, my lord.
Read.
3, my lord. The returning officer of the assistant returning officer appoint under the sub-rule 1 or sub-rule 2 shall within 15 days from the date of the constitution of the deemed constitution of the board after general elections. Within 15 days, my lord. See, returning officer selections has been fixed, my lord. See, elections held on 4/2. Election date has been fixed on 18/2 within 15 days, my lord. See, in the favoring of the nominating director, this elections is postponed, my lord. In view of the interim order, so violating, I'll read the annexure F, my lord, page number 18.
Yes.
Page number 18, last, my lord. ಮುನಿನಾರಾಯಣಪ್ಪನವರಿಗೆ ಮತದಾನಕ್ಕೆ ಅವಕಾಶ ನೀಡಬಾರದೆಂದು ತಿಳಿಸಿರ್ತಾರೆ. ಇಬ್ಬರ ಮನವಿಯನ್ನು ಪರಿಶೀಲನೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ತಡೆಯಾಜ್ಞೆ ಲಾಸ್ಟ್ ಮಿಲಡ್ ಲಾಸ್ಟ್ 2 lines ಮಿಲಡ್ ಲಾಸ್ಟ್ 2 lines.
Yes.
ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ತಡೆಯಾಜ್ಞೆ ಆದೇಶದ ಅನ್ವಯ ಸೊ ಮುನಿನಾರಾಯಣಪ್ಪ ವೀರ್ ಅವರಿಗೆ ಮತದಾನ ಮಾಡಲು ಅವಕಾಶ ಕೊಡುವುದಿಲ್ಲ ಅಂತ ತಿಳಿಸಲಾಯಿತು. ಆಗ ಅವರ ಮಗ ತಂದೆಯ ಜೊತೆಯಲ್ಲಿ ಬಂದು ಜೋರು ದನಿಯಲ್ಲಿ ಮಾತನಾಡಿ ನಮ್ಮ ತಂದೆಯವರಿಗೆ ಮತದಾನ ಅವಕಾಶ ಕೊಡಿ ಅಥವಾ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮುಂದೂಡಿ ಎಂದು ಒತ್ತಾಯಿಸುತ್ತಾರೆ. In view of this, my lord, the elections has been postponed. See, as per the class 14, my lord, where is the election stopped? Same has been continued by the returning officer, my lord. See, in view of the interim order, my lord, see, violating the interim order is a nominated director and his son. Is a postpone only for favoring of the
We'll fix a date and we'll dispose it of. AGA accepts notice for respondent 1 and 2.
3, my lord. 1 to 3.
1, 2 and 3. Urgent notice to the fourth respondent. Petitioner is at liberty to take out notice by way of hand summons as well. Others are not required, is it?
others is not required, my lord. It's only for
Make that person also respondent.
no, my lord, my lord, already Honorable Court has been stated this nomination is not
No,
proper.
correct. Now he is causing all the problem.
Huh.
So in his presence only we'll pass
My
it.
lord, it's violating section 14, my lord, within 15 days, once is elected body, my lord.
You are right, you are correct.
My lord, he questioned the appointment of someone without making him party. That is.
No, now we are saying no doubt, you are correct. That position, legal position is clear. Now the opposition is being made only by that one person whose directorship is stayed. We make him a party, now itself I'll give you permission. In his presence only we'll pass an order.
Yes, correct, my lord, but see, section is very clear, within 15 days.
You are right, counsel.
There is one more section, my lord, 28A4, there is a state government has the power to direct the nomination. The society being a sister society, they cannot say that you doesn't have any right.
Now let us see, I'll give you oral permission. You make that Muni Narayanappa as an additional respondent. Let notice go. Next date in his presence, we'll see what is to be done.
But meanwhile, my lord, this respondent, sir, is appoint the returning officer. Problem is, my lord, day by day activities is there, my lord, does he?
No, we'll have a short date. We'll hear all and we'll see what is to be done.
Meanwhile-
Election has to be held. So you make him a party. Petitioners makes an oral request to array Shri Muni Narayanappa as an additional respondent. Said oral request is acceded to. Amendment to be carried out forthwith. Emergent notice to the said respondent. Petitioner is also permitted to take out notice by way of hand summons. List the matter next week.
Next week.
Date.
Obliged.
Try to serve by the means. First time
My lord, wait for direct.
just 1 minute. The orders and interim orders of the previous. Request for interim prayers kept open is the matter in the orders list. Same with the previous also same. After first time, wherever interim prayer is there,
Obliged.
we'll not let it come in B group, we'll keep it in the orders,
Obliged.
list, consider and then put it to B.
Obliged.
Those matters that can be disposed of, we can have it in the preliminary hearing list. Yes.
My lord, this writ petition for a direction to nature of mandamus to direct the respondent number 3 to announce the result. My lord, the election held on 28/1/2024. Despite of order passed by this honorable court on 2 writ petitions. The kindly turn the annexure E, my lord.
Lord, I will take a hand.
Page
I will
number
take a
9.
notice, my lord. I will seek instruction why the election, because there are several direction from this honorable court. There may be one writ petition pending. I will take instruction and I will make
Let us-
submission.
Already disposed, my lord.
Correct, we'll fix a date, we'll find out.
My lord, please.
AGA accepts notice for respondent
1 to 3, my lord.
1 to 3. Emergent notice to the fourth respondent, petitioner is at liberty to take out notice by way of hand summons as well.
And more they did not make a party to the election authority, my lord, in this.
So you make that election authority, I'll give you permission now itself amended. The petitioner is permitted to array the
Cooperative election authority as a
Cooperative
party.
election authority as an additional respondent. Third Council Kiran Kumar directed to accept notice for the said newly added respondent. Amendment to be carried out forthwith. This is the matter in the preliminary hearing list.
Obliged.
It's only on that point.
Obliged.
Next week, date 7. You complete the service by then.
And my lord, we are not seeking any relief against the respondent number 4.
Let us see,
It
let
may
us
be
see.
dispensed.
Let us see. On the next date, we'll see whether notice is not. If they are served, well and good. Even if they're not served, I'll still consider a
Only
relief
on my submission.
on this.
Worship petitioners are disqualified from the voting of the 6th respondent society, Your Lordship. Election is held on tomorrow. 20th.
Same order.
Obliged, my lord.
Huh?
I will take notice for R1, R3, R4, R5, my lord.
Land Council,
R1,
AG accepts notice for 1,
3, 4, 5.
1, 3,
2 for
4,
Kiran
and
Kumar.
5.
6 is a society.
Kiran Kumar for R2. Emergent notice to R6. Petitioner is permitted to amend the spelling error in description of 5th respondent. Necessary amendment to be carried out forthwith. The same order. Thir- 13D2A Roman 1-2, isn't it?
That is one, my lord. Finally, there is one. If they are the members of the society, that may become.
Please.
Sometimes the few members without having membership with the society, they are getting right to vote. Adondu word.
Correct, that we'll see. No, now you are members.
Please, Your Lordship. I am in ineligible voters list. At Annexure C, my lord, page number 19.
All of you.
Please.
Annexure,
Annexure C, page number 19.
how many petitioners are there now?
Petitioner number 23, my lord. All the petitioners in ineligible list at Annexure C.
All of them.
Please.
What is the total strength?
Please.
What is the total
strength,
strength?
It is
59, is it?
59 is the ineligible voters.
Yes.
ಅದಕ್ಕಿನ್ನೂ ಜಾಸ್ತಿ ಇರ್ಬೇಕು ಸುಮ್ನೆ.
This is the matter on,
ನಾಳೆ ಎಲೆಕ್ಷನ್.
ನಾಳೆ.
29th ಇದೆ ಎಲೆಕ್ಷನ್.
we'll have it on Monday,
Monday.
Monday or Tuesday?
ಎನಿ ಟೈಮ್ ಮಂಡೇ.
Monday. This is the matter. Let it be in the orders list.
Obliged, no.
Orders list on Monday.
Please. Lordship, may kindly permit to hand deliver your
And
lordship.
we will upload. It will be uploaded immediately.
Please.
Apply for copy by, we'll upload it immediately.
Please.
Serial number 7, I appear for the review petition, my lord. This review petition has been filed, sought to review the order passed in WP 28/753 of 23, my lord. This order was, impugned order was passed, my lord, on the contention of the petitions in the WP, stating that the impugned order was passed under section 306 of the Municipality Act. But the perusal of the order makes it clear that the order was passed under section 322 of the Municipality Act, my lord.
Okay, take out notice, let us see.
I will serve the copies and the advocates, my lord,
Yes,
for appearing for the petitioners.
the. Petitioners permitted to serve, counsel appearing for the respondents in the writ proceedings. List the matter. Next week date. 11th.
Right.
Lord, it may be passer, my lord. I will file a memo.
Which one?
Serial number 8, my lord.
Plus,
Pass for me.
my representation is, my lord, requesting them only to conduct the election for the vacant post, my lords. The 4 directors were given their resignation.
Let us see what stand. Pass over.
Please, your lordship. I represent the petitioner. Now, the petitioner, who was a director, my lord, during the period 2014 to 2021, has questioned the order passed by respondent number 2, my lord, under section 68 and 69 of the Cooperative Societies Act, without giving any opportunity of hearing. Section 64(3)(b), as held by this honorable court, contemplates, my lord, giving of notice and holding an inquiry. What had happened was, my lord, he was director during that period. Earlier to, my lord, giving the property of the, my lord, society on lease. Kindly go to, my lord, ink page 138, man.
So let them take notice.
Now, my lord, what happens is, there is a common order against all the directors. I have challenged in so far as me is concerned. My lord, no opportunity has given. I was not holding the office during that period. Page 138 may kindly be seen for a moment, man.
138,
my lord. Allegation is 5 acres of registered 5 acres of land belonging to the society has been given on lease, my lord, to some parties. Registered lease deed was executed. I was not a director during that point of time. Now, my lord, based on assumption and presumptions, my lord, I have also been, my lord, indicted without giving any opportunity of hearing. And there is an order, my lord, to take action. Kindly go to, my lord, ink page 115.
Now, when were you a director?
My lord, I was director from 2014 to 2014 to 2021.
Now, what is the finding in the inquiry report?
Enquiry, my lord, kindly see, my lord, enquiry, the finding is page, my lord, 102.
What is the charge that was framed?
Charge is, my lord, the property belonging to the respondent number 1 society was given on for a lower rent. Thereby, you have caused a loss.
Just take me to the charge.
Page 102, man.
Yes.
Third paragraph. ಸರ್ಕಾರ ಉದ್ದೇಶಕ್ಕೆ ಒಳಪಟ್ಟು ಸ್ಥಿರಾಸ್ತಿಯಲ್ಲಿ ರೈಸ್ ಮಿಲ್ ಸ್ಥಾಪನೆಗೆ ಅನುಮತಿ ನೀಡಿದ ಪ್ರಯುಕ್ತ ಸಂಘವು ನಿಬಂಧನೆಗೊಳಪಟ್ಟು ಅಕ್ಕಿ ಗಿರಣಿಯನ್ನು ಪ್ರಾರಂಭ ಮಾಡಿ 2009ರವರೆಗೆ ಅಕ್ಕಿ ಗಿರಣಿಯನ್ನು ಚಾಲನೆಯಲ್ಲಿ ಇಟ್ಟು 2009 ನಂತರ ಕಾರಣಾಂತರಗಳಿಂದ ಅಕ್ಕಿ ಗಿರಣಿ ಕಾರ್ಯ ಸ್ಥಗಿತಗೊಂಡಿದ್ದರಿಂದ ಸಂಘದವರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕೃಷಿ ಆಧಾರಿತ ಕಾರ್ಯಚಟುವಟಿಕೆಗಳನ್ನು ಪ್ರಾರಂಭಿಸದೆ ಉದ್ದೇಶಗಳನ್ನು ತಿರಸ್ಕರಿಸಿ ನಿಬಂಧನೆಗಳನ್ನು ವಿರುದ್ಧವಾಗಿ 5 ಎಕರೆ ಸ್ಥಿರಾಸ್ತಿಯಲ್ಲಿರುವ ರೈಸ್ ಮಿಲ್ ಕಟ್ಟಡ, ಮಳಿಗೆಗಳು ಮತ್ತು ಖಾಲಿ ಜಾಗವನ್ನು ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ವ್ಯಾಪಾರಸ್ಥರಿಗೆ ಬಾಡಿಗೆ, ನೆಲ ಬಾಡಿಗೆ ಕೊಟ್ಟಿರುವುದಾಗಿ ವರದಿಯಲ್ಲಿ ದೃಢಪಡಿಸಿದ್ದಾರೆ. ಹಾಗೂ ಸಂಘದ ವಿಧಿಗಳನ್ನು, ಕಾಯ್ದೆ ನಿಯಮಗಳನ್ನು ಮತ್ತು ಷರತ್ತು ನಿಬಂಧನೆಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಆಡಳಿತ ಮಂಡಳಿಯವರು ತಮಗೆ ತೋಚಿದ ರೀತಿಯಲ್ಲಿ ಸ್ಥಿರಾಸ್ತಿಗಳನ್ನು 10 ರಿಂದ 30 ವರ್ಷಗಳವರೆಗೆ ದೀರ್ಘಾವಧಿ ಕರಾರು ಮಾಡಿಕೊಂಡು ವಾಣಿಜ್ಯ ಉದ್ದಿಮೆದಾರರಿಗೆ ಬಾಡಿಗೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಬಾಡಿಗೆಯನ್ನು ಇಲಾಖಾ ಅನುಮತಿ ಪಡೆಯದೆ, ತಾಂತ್ರಿಕ ಅನುಮತಿ ಪಡೆಯದೆ, ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ ನೀಡದೆ, ಪಾರದರ್ಶಕ ಕಾಯ್ದೆ ನಿಯಮಗಳನ್ನು ಪಾಲಿಸದೆ, ಯಾವುದೇ ಮಾನದಂಡ ಅನುಸರಿಸದೆ ಬಾಡಿಗೆಗೆ ನಿಗದಿಪಡಿಸಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಇದರಿಂದ ಸಂಘದ ಪ್ರತಿ ತಿಂಗಳು ಅಂದಾಜು 10 ಲಕ್ಷ ಹಾನಿ ನಷ್ಟವಾಗುವುದೆಂದು ಇತರ ಸಂಘಗಳು ನೀಡಿರುವ ಬಾಡಿಗೆಯನ್ನು ಹೋಲಿಕೆ ಮಾಡಿ ದೃಢಪಡಿಸಿರುತ್ತಾರೆ. ಆಡಳಿತ ಮಂಡಳಿಯವರು ಒಳ ಒಪ್ಪಂದ ಮಾಡಿಕೊಂಡು 3ನೇ ವ್ಯಕ್ತಿಗಳ ಹೆಚ್ಚಿನ ದರಕ್ಕೆ ಬಾಡಿಗೆ ನೀಡಿ ಸಂಘಕ್ಕೆ ನಷ್ಟವನ್ನುಂಟು ಮಾಡುತ್ತಾರೆ ವರದಿಯಲ್ಲಿ ದೃಢೀಕರಿಸಿ. ಈ ರೀತಿಯಾಗಿ ಸಂಘಕ್ಕೆ ಪ್ರತಿ ತಿಂಗಳಿಗೆ 10,39,819 into 12 1 crore so and so ನಷ್ಟ ಉಂಟು ಮಾಡಿರುತ್ತಾರೆ. ಒಟ್ಟು 12 ವರ್ಷಗಳಿಗೆ ಸಂಘಕ್ಕೆ ಆಗಿರುವ ನಷ್ಟಕ್ಕೆ 2008-9ರಿಂದ 2013-14 ಹಾಗೂ 1-4-2014ರಿಂದ 2019 ಅವಧಿಯಲ್ಲಿದ್ದ ಆಡಳಿತ ಮಂಡಲದ ಸದಸ್ಯರು ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಹೊಣೆಗಾರರಾಗಿದ್ದು ಅವರಿಂದ ವೈಯಕ್ತಿಕವಾಗಿ ಜಂಟಿಯಾಗಿ ಕಾನೂನು ವಸೂಲು ಮಾಡತಕ್ಕದೆಂದು ಮಾಡಲಾಗಿದೆ. I was not there during 2009. By that time, registered lease was already executed.
No, correct, sir, but they say continuance of the lease.
Continuance, I being a director, my lord, I have registered lease, my lord.
Lord,
My lord, notice has to be given, my lord. That is the dictum. That is the dictum of this honorable court. Kindly see, my lord. Sorry, my lord, it is court kacheri. Yara, may I pass on there? Paragraph 6, my lord.
But you have not challenged the 64 inquiry.
A report and now challenge madlik barodilla.
Lord, may I request?
Report I cannot challenge. While submit, my lord, on the basis of report, my lord, now joint registrar has passed an order as per annexure B, my lord.
Under 69.
68,
my lord.
68, and directs, my lord, to the concerned authority to.
68, there's no remedy, is it?
My lord, in
There
it
is
is a violation of principles of natural justice, and I have not been given mandate of this honorable court has not been followed.
No, that you can raise in the appeal.
My lord, appeal, my lord, appeal means now 69 is also followed. My lord, even that case also, my lord, writ petition was, there is no.
No, that is there, but why can't you file an appeal?
My lord, because my lord.
I'll give you protection for a limited time, you file an appeal. Let the appellate authority do it. Till they consider, your the request for interim prayer.
Now joint director has passed the, joint registrar of cooperative society.
So what is the remedy now under the statutory scheme?
My lord, 106, my lord, 106H.
106?
106H, their appeal to the, if a order is passed by the joint registrar of cooperative, additional registrar hogutte.
106.
106H, my lord. '68 direction.
An order of the registrar under 68. Now I'll give you protection till he considers your appeal.
Only one submission, man. The registrar, assistant registrar directs the special officer was there, to comply with the directions. He sought for time. No time is given, and order is passed. On the face of it, my lord, is in violation of principles of natural justice.
Lord,
Ultimately, that has to be, I have to be given an opportunity. That can be done, my lord, after hearing the other side, my lord, so that.
Let it be done in the appeal proceedings. I'll protect you till your request for interim prayer against the direction under 68 is concerned.
Lord, one request, my lord, one submission may make, my lord.
Yes.
My lord, this order at Annexure B was passed.
Annexure?
Annexure B, my lord, that is a 68 direction issued to the society. He is not aggrieved by that, my lord.
I am not, I have been inducted without.
If he will not be in that position, my lord, he will not be punished. My lord, page 24, my lord, he has not produced the entire booklet, what he is reading. Page 24, Annexure B, my lord. Annexure B, that is impugned order, my lord, at 15/7/2022.
Annexure?
Annexure B.
That is after passing of the order, my lord, the special officer passes a resolution to initiate inquiry under section 69.
69 is a surcharge proceedings, my lord. May I read section 65 first, my lord. This order was passed subsequent to the order of inspection under section 65, my lord. Where section 65 inspections were made, no necessary need to issue a notice to the concerned person, because they will issue notice to the society, and society will produce all the documents which are available at the hands of the society. The authority will go and inquire, inspect the documents, inspect the original document, and he make a reports, my lord. If at all something and irregularities happened in the society by after inspection of the original records, then he will make an 68 direction to the society to comply with the so-and-so, so-and-so. If at all the society has complied all the formalities, and they can submit a report, complaints report saying that we have not made any irregularities, we have complied with so-and-so, so-and-so. There is a board resolution saying that the board has taken a decision, we have complied all those things, they will submit. That was not made by the board, my lord. The board has failed to do its function.
Board was not there.
The board has failed to perform his function. Because of that reason, 69 surcharge was issued, my lord.
No, correct. Now, I'm saying without entering into the merits.
Obliged, no.
If he's a person against whom 69 proceedings are now to be initiated,
Obliged.
it's for him to make out. Let us.
That out.
Till then, my lord, protect.
Yes.
Now there is an order under section 68 directing to take action, surcharge, initiate surcharge proceedings under section 69. That's why I have.
The petitioner has called in question the correctness of the order annexure B, whereby the joint register of cooperative societies has initiated proceedings under section 69.
69 surcharge proceedings, my lord.
68 and 69. He has
68
passed
is
an
the-
order under section 68 directing to initiate page 1151.
Has initiated proceedings under section 69 pursuant to the inspection report under section 65. Full stop. Under 68 and 69. Full stop. Though various contentions have been advanced, including that the petitioner was not the director during the relevant point of time. However, noticing that there is
And
a-
no opportunity was given.
and that no opportunity of hearing was afforded as mandated, taking note of section,
My lord,
106
section
H.
106H, my lord.
taking notice of existence of alternative remedy under 106
H.
H, which provides for an appeal against an order of the registrar under section 68. It would be appropriate to relegate the petitioner to avail of the statutory remedy. Full stop. In the present case, proceedings at annexure B are pursuant to the order of the registrar under section 68. Full stop. Accordingly, petition is disposed of, reserving liberty to the petitioner to challenge the proceedings and order at annexure B in accordance with law by availing of a statutory remedy of appeal. Full stop. Needless to state. Full stop. Next. Learned counsel, senior counsel appearing on behalf of the petitioner submits and statutory remedy would be resorted to by way of appeal within a period of
30 days. 30 days.
2 weeks you file.
Please,
In a period of 2 weeks.
please.
Full stop.
Limitation, they may not insist on.
If appeal is filed as undertaken within a period of 2 weeks, the appellate authority under the statute is not to raise any objection regarding limitation
My lord, may I request, my lord?
and
My lord, this order was passed in.
No notice has
22.
been issued, man.
This order was passed in the year 2022, my lord.
No notice is issued.
He cannot say that limitation, it is authority to
Heard.
decide whether the section 72, my lord.
Main ground is a violation of principles of no notice, even to the society of
The
special
restriction itself
officer.
is not maintainable. How can he
no, let us see.
seek a relief against the limitation?
Let us next in further, the respondent authorities are not to take any action pursuant to annexure B insofar as the petitioner is concerned till prayer for interim relief is considered.
Consider.
All contentions are kept open.
Please. Oblige.
EG accepts notice, Vidya. Accepts notice for the respondent. Notice with respect to the other respondents is waived in light of the disposal of the matter, relegating the petitioner to avail of statutory remedy. Yes.
And, Petitioner G.
Weeks time granted for compliance.
11.
Unexcused B is not legible. I will replace it, my lord, with a legible copy. The elections is scheduled to be held tomorrow, my lord.
Same,
Same,
13D,
please, my lord.
same order. AGA accepts notice for respondent. 1,
1,
3, and 5.
please, my lord.
Kiran Kumar for 2.
2,
Emergent notice to the 4th
5.
respondent. Petitioner permitted to take out notice by way of hand summons as well. ಅದೊಂದು ಲಿಸ್ಟ್ ಮಾಡ್ಕೋ ಯಾರ್ಯಾರು ಈ societies go ಯಾರು ಬರ್ತಾರೆ.
Much.
Relist the matter. When is the election?
Tomorrow, my lord.
4th. In the orders list.
Orders, seal number 12.
Weeks time granted for taking up necessary steps.
13.
Lords appearing for petition, my lords.
Hearing for respondent number 1 and
Lords, on
3,
the
my
last date, my lords, the coordinate judge had directed me to implead the society as party, my lords. Lords, I've impleaded society, I've amended I've filed a application, my lords, to amend respondent number 3, my lords, because the society is represented by executive officer, my lords.
My lordship,
I appear for the society.
my lordship, in this matter, I'm
No,
appearing
who
for.
have you impleted now? Amendment is
They
filed.
sought
Yes, my lord.
amendment for.
I've sought-
In the writ petition, they made the respondent number 3 as executive officer. Now they sought amendment for society represented by the executive officer. In this writ petition, challenging is selection of the respondent number 1 as selected as an executive officer.
Then so far as the amendment, you have no objection, isn't it?
No, my lordship, if this amendment is carried out, contesting respondent himself, he has to appear as a respondent number 3. He's the respondent number 1 is the contesting respondent.
My lords,
He himself as a executive officer.
What is the main relief?
my lords,
Selection of the executive officer is challenged in this
So,
petition.
the first respondent selection.
Please, my lordship.
Then we will direct,
President may be represented by the society, my lordship.
he is there at second.
Yes,
Second,
Second is
instead of
already
3,
there.
second,
Second is already there.
please, my lordship.
Now, for the, we'll make an order that in light of executive officers election, selection, having appointment, having been challenged,
Please,
the president will represent the society in this matter.
please, my lordship.
Society I appear. So, correct. So instead of impleading instead of impleading.
R3, my lords.
13 serial number.
I'll implead R2, my lords.
Sorry, my lord.
President of the,
Sorry, my lord, 14, sorry.
I undertake to appear for the society.
R2 is the president of the society, my lords. R3 is the executive officer of the society, my lords.
So we'll say the description of the second respondent, we'll direct him to amend as a society represented by president
Please, my lordship.
and pass an order stating that since the selection of the appointment
Please,
of the executive officer is in question, society in the present matter will be represented by the president.
please.
Isn't it?
Yes, ma'am.
So you have challenged the.
I have,
Challenge the.
my lords, petitioner have challenged the election of respondent number 1 as to the post of chief executive officer, my lords.
Selection of.
Respondent number 1, my lords.
Officer,
As
To
the
the post
chief
of chief executive officer.
And normally society is represented by chief executive officer.
Yes, my lords.
as per section 29, G4, subclass JL,
29.
G4. Clause J.
Lords, I have amended, yes, my lords.
Just wait.
Yes.
G,
4 ಅಲ್ಲಿ, subclass J ಅಲ್ಲಿ ಹೇಳ್ತೇನೆ.
the chief executive shall
Who
be
may
the
be
chief
students who are on
administrative
behalf of-
officer.
Please.
Lord 29G, my lord, J.
Yes. Right, but now, because of his very appointment being an issue,
Obliged.
we'll make an exception.
Please.
Yes, what were you submitting?
My lords, the order itself and at Annexure A, my lords, is passed by the Chief Executive Officer who was present at that time, my lords. So that is why I have,
He's somebody else.
yes, my lords.
Correct.
Now at this moment, my lords, the respondent number one
One
is at the
minute.
post of Chief
So
Executive.
his issue is at hand.
Yes, my lords.
The counsel for the petitioner submits as the appointment of the first respondent as a chief executive officer is in challenge. The society may have to be represented by any person other than the chief executive officer. Full stop. Accordingly, taking note of the nature of subject matter of dispute as an exception in the peculiar facts of the present case, the president of the Villinelle Primary Agricultural Credit Cooperative Society would represent the society for all purposes. Full stop. Accordingly, the description of the second respondent to be amended as follows. Villinelle Primary Agricultural Credit Cooperative Society Limited, represented by its president, address same. Necessary amendment to be carried out forthwith.
I'll do it course of the day, my lords.
Now, who appears for the society? Learned counsel so and so undertakes to file wakalat for the second respondent. Now, what about the
There are
others?
2 weeks time may be granted to file my
Allowed.
objections, my lord.
Lords, one,
Oh, just 1 minute. IA 1 of 24, you dismiss as not pressed.
yes, ma'am.
Huh?
Yes, ma'am.
You file a memo.
I'll file them.
IA 1 of 24 is dismissed as not pressed. When have they served copies?
My lords, on 5/12 itself, my lords, we have served.
We'll have it on next Thursday, you get ready. Serve copies.
Yes, my lords, we'll serve it.
Consideration of interim prayers kept open, list the matter in orders list next Thursday. You at least get oral instructions on the interim relief. Merits will give you time.
Already interim prayer is granted.
Considered.
No, my lords, it is not considered yet.
It's considered, your lord.
Lord, in every service matter, there will be subject
we-
to outcome of the writ petition, my lord. In case the petitioner
To the result of
will not
the
succeed
present-
finally, then no one will bear the cost but suffered by the respond number one. Because his appointment will be subject to outcome that will be normally interim order in where recruitment is made, my lord.
So let us see then. Let them file the.
Finally, it has to be heard finally, my lord.
Statement of objections to be filed within 2 weeks.
Please.
List the matter immediately thereafter.
Lords, one date may be given. my lord.
Now let us see. Let them file, then you move.
Yes.
You don't leave her until she files.
Like,
14, Sandesh TB.
Not voting right.
I serve the hand summons to the
Now you accept notice for respondent.
Respondent 5. First, now the
That
Elections
Sri
are
BL
finished.
Sanjeev accepts notice for respondent number 5.
Declare matter.
Yes, what is the stage of the proceeding?
Lords, elections are over, my lords. Elections on 25 to 24. Now the result not announced, my lords.
Lord, on the last occasion, there was an interim order passed by the Honorable Court saying that the elections could be held
And the petitioners, my lord, the separate box is to be kept, that has been kept. Now, my lord, it has to be heard, and on the last occasion, there was a submission made by the petitioner counsel saying that if he is not done the minimum service, he will withdraw the writ petition. That was he was supposed to file an appeal.
No, so in all matters, what we can do is after they have got the benefit of interim order, we'll ask them to file an affidavit stating that they fulfill the criteria under Roman 1 and 2 of that rule.
20.
If there's any other ground, let the society say, that's all.
That's only, my lord, one thing I want to. bring
Lords,
to
they
notice of
have
this honorable court, my
follow
lord.
the rule 13th of the.
The society before this court, my lord, if they says that he did not do a minimum service, then if they shows that they did not do minimum service, then
Then it
has
goes.
to be goes.
Correct.
Obliged, my lord. If society says that they did, but we did not serve a notice under 13.D.2.A, then they will succeed, my lord, in such a situation.
Correct. So what I'm saying that actually what we should do now is that even at the time of filing of the writ,
Obliged.
we should, and time of getting interim order, we should ask them to file an affidavit enclosing that they're not disqualified under those rule 1 and 2.
My lord, my
At
lord,
least,
I
if there's
oblige.
any other ground, that's a different matter which we can.
Yeah, I agree, my lord. While granting an interim order, the petitioner prima facie he should show that he did a minimum services.
Correct.
Apart from his doing a minimum service, the society is put him under the ineligible voter list without issuing notice. That will be a different aspect. But here they will come before this court without having such evidence to show that they were served a minimum services.
So we'll start.
Lord, in a milk society,
ಇದರಲ್ಲಿ
they
ಅದೆಲ್ಲ
will be having a
ಮಾಡೋದಕ್ಕೂ ಮುಂಚೆ
passbook. They will be having a passbook. If they produce that passbook, then it is there, ends the matter. They did not produce the passbook and they did not show that they taken a minimum services. They vended 180 liters of 180 days milk, 500 liters. They did not show that. In the event that, my lord, they have to show before this court
Now
in
we'll
a
start
special circumstance. This court should entertain such a writ petitions where it is
So
totally barred.
We'll impose condition.
Obliged.
Now onwards, when we are looking at it, that within 3 days they have to file an affidavit that they don't suffer from disqualification as so and so, producing copies also, we can insist.
Obliged.
Now, in this case, can you not find out?
No, I've brought it.
My lords, I have
Filed
produced
application.
the,
Filing.
what is this?
Filed all the, to what the minimum services they were supposed to do and all. On the last occasion, your lordship, the order passed by this honorable court is, learned counsel for the petitioner has made a statement that in case the proof relating to the minimum service availed by the petitioner are not produced by the next day, the petitioner will withdraw the petition with liberty to raise an election dispute. Now, my lord, the elections are held. And my lord, the notice, my lord, was given well within nearly about 1 year back. That is 8/12/2022. They come at the fag end of the, my lord, after the election, they come before this honorable court and they make it. And my lord, this honorable court has passed a specific order saying that they'll have to produce. My lord, if he has not produced, my lord, he has to.
Definitely, my lords, I have produced the entire documents relating to the minimum services, my lords. I need time to, for 2 weeks, my lords.
No.
2 weeks.
When you are getting an interim order, at the time of filing the petition only, you should have filed.
Because, my lords, total 160 members are there, my lords.
That is, who said it? When you are filing the petition,
Please, my
when
lords.
you charge fees for him for one petitioner, whatever, that time only you must tell him, you must give all this information.
Definitely, my lords. I pray for 1 week time, my lords. Definitely, I'll do the needful, my lords.
Results be declared. If at all he wants it to go before the, under section 70, my lord, he is free to
raise a dispute.
That is the undertaking given by him. My lord.
Therefore, my lords, all the petitioners are await the minimum service.
File it by Monday. I'm not going to give 1 day beyond Monday. File it.
Please, my lords.
The petitioner to file affidavit enclosing details regarding minimum service availed by the petitioners so as to avoid disqualification by Monday. Now, what is your instruction?
My instruction, my lord, I have filed the complete set, my lord, of the services of each of the petitioners before this honorable court, saying that the minimum services have not been.
Not.
Petitioners have a passbook on this,
Just take me to any one, just explain that.
First petitioner, my lord, the first petitioner. That is Somshekhar, he is not before this honorable court, my lord. Second one, my lord. That is in. My lord, second, third one, sorry. Two are not there, my lord, E.N. Channegoda. My lord, he has not, my lord, attended the, and service, my lord, he has not done it.
The third is Raghavendra, isn't it?
Yes.
Raghavendra.
Third,
At page,
B.N. Chennaigoda at annexure R17, my lord. R1 page 7, ink page 7 that.
7.
yes, Chennaigoda.
Chennaigoda.
Third,
Yes, yes.
because my lord, one meeting he has not attended. And as regarding the services, my lord, he has not at all. That is supplier. Kanishta seva saulabhya padadiruva batu vivar.
That's completely blank.
Yes.
So we'll ask him to file a, now we should insist even at the time of giving interim order that they have to demonstrate
Yes.
that they are not.
They have to demonstrate.
They have to demonstrate that we'll start doing it from next. Petitioners affidavit filed should advert to attendance in the general, in the attendance in the
Attended the general body
meeting, as well as availment of minimum services, so as to ensure that they don't fall within the clause for disqualification provided for under
section 20.
20A4 and A5. A5 is the minimum service.
20 Roman
A5.
A5,
Pledge.
and which is A4 and 5.
A4 and
Lord,
5.
A4 relaxation has been done by these honorable.
So that you
court.
state, Roman A4 and A5, full stop. Needless to state, the relaxation will provided for non-attendance of meetings during COVID time is also a matter to be adverted. So you file it by Monday. Made clear that if affidavit as ordered is not filed, court would proceed with further orders. Relist the matter in the
by-
orders list on Monday.
Wednesday, my lords, by Wednesday.
You should
I
be
collect
ready.
the, all the documents and by Wednesday, my lords.
No, why do you file then for 150 people?
This is a case where he has to go before the. section 70.
Definitely, my lords, I do.
After the elections, it has been entertained. And this honorable court warned him also, saying that you will have to produce it by the next day. Now, my lord, the elections have been held, counted also, we are not able to
Get the result out.
declare the results.
By Wednesday, my lords.
Wednesday.
Much,
I'm not going to give any further time.
much.
The order is this.
Hearing AS 15. Read that, Prabhu.
Lords, for the respondent.
I filed for the petitioner, my lords.
Yes.
I filed a petition under section 29A5 for extension for a further period of 6 months to pass the award, my lords.
My lords, copy has not been served on me, my lords. I'm for the respondent.
Sir, I have sent it to your party by mail. If you have a copy, then you just give it to you for the time being. Can I
My lords,
You serve a copy, we'll have it tomorrow.
my lords, one submission is nothing survives as of today. The arbitration proceedings have been closed. I'm filing a memo from the email of the DIAC, my lords, that the proceedings have been closed for non-prosecution. In fact, this is your lordships had passed the order, my lords,
On?
on 8th March 2021. The final order, my lords, in this matter. It was your lordship's order, my lords. Your lordships had first referred it to Mediation Center.
On 8th March,
8th March 2021, my lords. Final order, my lords.
My lords, I'll serve a copy on the council. It may be taken tomorrow because the arbitration proceeding is pending and I have produced the copy of the order.
I'll accommodate. Let's see what is submitted.
Very well.
My lords, on 8th March 2021, your lordships had allowed the section 11 petition. Your lordships had in fact directed the matter to mediation center. The mediation failed because parties did not appear there. And thereafter the arbitration proceedings was initiated. They did not file their claim statement and the arbitration was before the Delhi International Arbitration Center. Now the DISC has sent an email on 15 January saying that the proceedings have been administratively closed. Please refer my memo, my lords. For a moment, I would take your lordship through the memo that I filed. That's an email from the DISC, my lords.
This section 11 appointment, even in
Yes,
case
section
of-
11, appointment of arbitrators.
Even in case of international arbitration can be done by the single judge.
My lords, no, my lord, this matter was referred to the DISC. It's not an it is not an international arbitration center.
Now, where is the?
Please see the email, my lords. Email is at page 2, my lords. Please come to page 3. At the very top, they say the proceedings in the matter in the center have already been administratively closed.
Page?
Page 3, 4, my lords. 3, my lords. 3 at the top.
And this is within the time.
Yes, because they have not filed their claim statement before that.
This is within the mandate.
Yes.
My lords may kindly turn to my petition. I'll serve a copy which may be taken up tomorrow, but my lords may kindly turn to the arbitration proceedings itself. I have produced the proceedings. My lords may kindly turn to, in my application, Annexure C, page number 21.
Then please check.
Annexure C, page number 20.
Serve him a copy.
I will serve a copy, my lords.
Please
And-
take it out.
And also
My
I
lords,
will.
Patter, I would know.
But look at what he's giving.
Yes.
I will, my lords. I will take a look at
Have
it.
a look at it.
Please, my lords.
Because this is also, my lords, this has been referred to a council, to me by a council from Delhi. So I will seek necessary instructions on
Yes.
this also.
We'll have it on Monday.
My lords, if it could be
Fix for
tomorrow.
Tuesday,
because
my
the-
lords.
On Tuesday.
My lords, may
Please,
I
my
request tomorrow because the mandate is expiring tomorrow.
Okay, we'll have it tomorrow. You find out then.
Yes, my lords.
Please,
I will seek necessary instructions and I will make my.
Memo filed on behalf.
May I
of
request it
correspondent
tomorrow, my lords?
Taken on record. Release the matter tomorrow.
Please, my lords.
Right.
My lords, they may be directed to serve a copy of the.
It is
Sir, I will
correct.
do it right now.
Now, one of it is correct, so please verify.
Please, my lords.
I will do it right now. Just give me.
Please, my lords. Grateful.
16.
I appear for the petitioner, my lord. I pray for a short accommodation in this matter, my lord. Senior is held up in court hall 23.
Request. List the matter.
My lords,
Week
may
after.
kindly produce the order sheet.
Let us see. Let us see. He's asking it. Relist the matter next week.
Yes.
Yes.
17. Serial number 17, Devi Prasad Shetty.
Lord, my learned friend has filed vacating application. Matter could be taken up next week, Lord, matter may be heard finally. Next week or 2 weeks.
I can relist the matter on date 13th.
Interim order maybe.
The matter earlier granted is extended in the next date. Let it come in B group only. Next week, we'll give a date in B group. Yes. No, we'll take it in B group. If it doesn't reach at 1:30, you make a thing, we'll take it. Yes.
18. Vikram Ji.
Petitioner. In this case, my lord, all these
Respondent.
orders are.
He was somebody moved for time.
Yes.
You appear for?
Respondent number 8.
My
lords, in these batch of matters, my lord, I appear for the respondent, the contesting respondent, my lords.
The respondent is seeking for an adjournment. The other respondent.
My lord, the matter may have to be considered, my lord, whether the provisions of surface will prevail over the provisions of KPID or vice versa, my lords, would have to be considered. So my lords may fix a date at their convenience, my lord, so that the matter could be heard, please, my lord.
Files, both of you will file a synopsis.
They
Please,
have
my
not
lord.
even filed their objections, my lord.
Huh?
None of the respondents have filed their
meantime,
objections.
Now it's a
Impleading applications will have to be allowed. R2 to R3 to R8 are the respondents ought to be impleaded. They have to be allowed and we'll file our objections, not if any.
And file of synopsis of some legal question.
Yeah, yes.
So we'll allow the impleading applications.
My lord,
Please.
the impleading applications may kindly be allowed, yes.
Will allow.
To be allowed.
To be allowed,
18.1.
partly in there.
18.1, notice has gone on the IA, is it? IA 2 of 23. ಹೋಗಿದ್ಯಾ? ಯಾರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ? Who appears for the impleading applicant, IA 2 of 23? In C number 18.
Pleading application is filed by the petitioner, not at the instance of the honorable court, my lord.
Lord, this court wanted me to implead those persons who would be affected. In the sense, they were all the guarantors and the principal borrowers of the loan
Notice
that
gone
was
to
available.
them.
Yes, my lord, we are all on record, R3 to R8.
So IA 2 of 23 we can allow.
Not
Yes.
I for R3, my lord, say it can be allowed.
IA, you appear for R.
Proposed R3.
That is,
In
But the
proposed
impleading
R3
application came to be allowed on the directions of this honorable court, so let it be allowed, my lord.
it's allowed.
No. Impleading application, no, this court directed me to file an impleading application to bring the borrowers and the guarantors on record.
Correct. So now we are on the point that notice has to be served on the impleading applicants, isn't it?
Notice has already been issued by this court, my lord.
Correct. Has it been served on all of them?
Yes, my lord. At least the cause list does not say that it has not been served. Serve ಆಗಿದೆ ಅಂತಾನೆ ತೋರಿಸ್ತಾ ಇದೆ.
R3.
It is noticed that notice has been served on IA 2 of 23 on all the proposed respondents 3 to 8.
Yes, my lord.
Now who appears
But for R3, I appear for R3.
for R3?
Alla, for R2 and R3.
Venkat
Arbitration appears for R2 and R3.
R2 and R3.
undertakes to appear for
R2 and R3. I have already filed wakalat.
R6, Rajaditya Sadashivan, my lord,
Filed
he has
wakalat.
filed this.
has filed wakalat
For
the
R6.
proposed impleading applicant number 2 Raghavendra
And R3, yes.
Yes.
and Mrs. Prime Estate.
Yes.
Okay, what about the remaining? Anybody has filed?
My lord, R6 Sadashivan, Rajaditya Sadashivan, my lord, he has filed his wakalat.
So far as R6, Council Rajaditya Sadasivan has already filed wakalat.
Wakalat. And insofar as R8 is concerned, my lord, Gaurav GK.
Shri Gaurav GK has filed wakalat for R8.
Yes.
Office to show the names of such of the council representing the proposed respondents.
My lord, proposed respondents R3 and R7, notice is held sufficient.
And so far as proposed
R4.
impleading applicant,
R3 and R7.
Shri Ganesh HK.
R3, you are filed wakalat. My lord, R3, my learned friend has filed wakalat. Very R7.
Just 1 minute. Please go to the application. We'll mention the names, otherwise there's going to be a confusion. In so far as the proposed impleading applicant who have been served with notice but not represented by the council, that is Shri
Ganesh HK and
Ganesh HK and
My lord, and Sri Rama Ramamantapa, Rangamantapa.
and Mr. Sri Rama Rangamantapa
Prasad Traditional Resort.
and Prasad Traditional Resort.
Result.
Names of the said proposed respondents to be shown as served in the cause list.
Yes.
Okay, what about the next one? 18.2.
My lord, 18.2, with the production of the certified copy of the Gazette notification, my lord.
Of 23 is allowed and production of certified copy of annexure A is permitted. In light of, it's produced, is it?
Yes, I have produced a photocopy.
In
The
light of.
Gazette notification, my
In
lord.
light of photocopy having been produced and no objection taken to its authenticity.
My lord.
Relist the.
My lord, insofar as 18, my lord, writ petition 26011 of 2023.
Yes.
My lord, I have filed an application seeking modification of the interim order. The interim order is granted in my favor, but while granting an interim order, my lord, reliance is placed on, may I request my lord to kindly take the order itself, my lord, passed by this honorable court on 27/11/2023. I have the benefit of an interim order, but this interim order, my lord, is based on the interim order passed
in writ petition 22835 of 2023, the reference to this writ petition is incorrect because in writ petition 22835, on which reliance is placed, is this was a writ petition where, my lord, I had challenged the summons issued to me. And that order also was stayed. What is challenged in this writ petition is the government notification attaching certain properties. So those writ petition numbers, my lord, are at
But then it may have to be passed by the same judge.
It's a typographical error. It looks like a typographical error. Reliance should have been placed, my lord, on the interim order passed in writ petition 21344 of 2023. I have filed an application seeking modification.
No, now if that is deleted, then what is to be substituted?
My lord, it has to be substituted. I have filed this application, my lord.
No, let it go back and come only on this. List may not be proper, a procedural formality.
There is
Let it go before the same.
Lord, all the councils, if we have no objection, my lord may do it.
That's a different matter. It's a procedural requirement. We shouldn't step on others' toes. IA 2 of 23 is to be placed before the same presiding officer. And relist the and accordingly necessary steps to be taken to list the matter. We'll fix a date.
Please.
On 7th.
Much obliged, my lord.
Now, what about the merits of the matter? Statement of objections?
No one has filed their objections.
You filed it.
We'll file.
No, we'll file, my lord, the statement of objections, my lord, and also the gist of citations, please, my lord.
Within.
Before 7th.
Within 15, please, within 15 minutes.
Statement of objections by the respondents to be filed by 15th. List the matter on 18th.
Please, my lord. Please, my lord.
Synopsis. Detailing list of dates, summary of legal contentions and authorities relied upon, also to be filed by the next date.
Let the interim orders may kindly be extended.
In operation are extended till the next date.
Next date.
Obliged, please.
List the matter in B group. Let it come in B group.
Much obliged.
Settlement 19.
Appearing for the petition, Your Lordship. This matter, last year they gave an OTS scheme. As per the OTS scheme, 4,35,000 was asked to be paid. We've already paid half the amount. And most recently, we've paid about 30 lakhs, Your Lords. In the meanwhile, there is a sale notice that they've taken out. Lords will see at page 17, the additional documents that I've produced. Earlier to this, there was a stay of the seizure notice taken out by the respondent bank. Pursuant to that, now they've taken out a
So who appears for the bank?
I think there's a.
Who appears for the bank?
Madam who's on record.
Go back here.
Since the seizure notice itself is stayed by the Honorable Court and we've also paid there and also we've paid for as per the OTS scheme. We've sought for 60 days time to pay the balance amount, Your Lords. Let them not precipitate further because we've already paid half the amount.
Who appears for the bank?
One Shobha, madam.
No, now there's already an interim order.
Please, Lords, but they've issued a sale notice.
Correct, but you are required to report settlement.
We've already paid about
Correct,
50
now
lakhs.
that's a matter between you and the bank.
Please, Lords.
Ah,
We've already
if-
paid 50
if you-
lakhs.
If you settle, you have to settle it.
Yes, Lords, we're given a representation yesterday also saying we sought for 60 days time. In fact, produce an MU, who is already as part of the funding is raised about 50 lakhs from part of the funding. Another 60 days he'll be done, your Lords. And he's also paid continuously for the last, since the OTS is offered about crore 35 lakhs is paid, your Lords. It's just a matter of 1 month, your Lords. But since they've issued sale notice at page 19 annexure Q, my only request is not to precipitate for some time then.
Right, if you have to settle, you have to settle it.
Please, Lords,
What can the court do in these matters?
another 30 days we'll complete, your Lords. Let them, because sale notice has been issued now, while the seizure notice itself is stayed.
It is noticed that interim order was passed by this court on
Lords, 28/3/2018.
on 28/3/2018. Now that condition you have.
That is already completed, Lords. Further to this, OTS was offered to just close the account.
It is submitted that the payment as mandated under the order of 28/3/2018 has been complied with.
Please, Lords, we have also filed a compliance affidavit, Lords, before the court.
It is submitted that despite such interim order having been granted, the respondent bank has what has happened now?
Now a sale notice has been issued, Lords,
At page?
at page 19, Lords, with the additional documents that we have filed.
Has issued a sale notice. Under provision of the Surface Act. Taking note of what is the date for public auction?
Lords, 29th tomorrow. The second row.
Taking note of the interim order passed earlier. Which is the seizure notice. The respondent number,
Respondent. Only one respondent.
respondent is restrained from taking, from proceeding with the public auction at an execute till the next date. No representation on behalf of the respondent when the matter is called out. This is the matter after 2 weeks.
Grateful.
No, but you have to enter a settlement with the bank.
Bank already settlement is done, your Lords. The OTS scheme is accepted and we've already paid 1.5 lakh, crore and a half. Today we're paying another 25 lakhs. So we are making payments. Just that we seek another 30 days. Maybe by next couple of days they'll be done, your Lords. Grateful.
Yes. Bank, nobody comes.
We'll intimate them. In fact, the client was there last evening with the bank, just to seek time. Grateful.
Passed over matter, seal number 2, Raghunath MD.
List the matter before the roster bench.
Tomorrow itself. Or 2:30 also.
After obtaining necessary orders at the earliest, you move a matter,
Not
move a memo.
because there should be an order of Chief Justice and it has to be posted. Unless my lord says tomorrow, it will not be listed.
Office to list the matter before the roster bench. As it appears that the classification of roster, there's an error in classification of roster. List the matter tomorrow.
Eight, R. Shashidhara.
Password. Next, CP list. CP list.
List to two matters. Serial number 1. Shruti SP. List to two.
At least worry about it. It will be taken on. We got B group of list 1. List 2 will be taken at the one. Password.
Serial number 2.
Password.
Ramakrishna.
Case status I will check my.
Serial number 3. Vishwanath MS. 3.
Yes.
For the petitioner, my lord. This is the transfer petition from Bangalore court to Chennai Senior Division Court, my lord. Here in this court, my lord, the suit for eviction filed by the respondent number 1 against the petitioner, my lord. Both are brothers. And the
suit for eviction filed by?
Eviction filed by the respondent against the petitioner.
You know, which is that? Annexure?
Annexure, my lord. Page number 16, my lord. Annexure A.
OS?
OS number 26,392/18. His own brother, my lord.
For possession?
Yes, possession. And kindly annexure B, my lord, page number 23. The petitioner filed suit for partition. Sorry, man. Page number 30, annexure D, man. That is the written statement at annexure B.
Which is the other suit?
Other suit filed by the petitioner against the respondent and other family members in OS number 107/2018 before civil judge Chennai. Page number 30, annexure D, man. In which item number 1 of B schedule property is the schedule property here in man. Page, my lord, 30, man.
30.
107
of 2018.
18. In this case, second dependent is the respondent number here in mind.
Now that suit is filed by?
Petitioner herein.
Yes. And the second defendant in that suit?
Respondent number 1 here in mind.
Is the respondent number 1.
Respondent number 1, and who is the plaintiff in Bangalore court, my lord, is the.
So this is a suit filed for?
Partition. petitioner filed a suit for partition against the family members, in which item number 1 of B schedule property is the scheduled property here in Bangalore, my lord. Kindly.
424.
425, yes, my lord. Page
Now
number
that is
30.
the same as in the present, as in OS 26392.
Same property, my lord.
Where is the schedule in the OS 26392?
Schedule, my lord, property bearing number 21, my lord.
Where do you get it?
21, my lord.
Page?
Page number 21.
Four 24. Yes.
425, the same property, my lord.
So now you are seeking for clubbing of both suits.
Yes, my lord. Because issues also framed in partition suit.
Now what is the stage in the partition?
Both
suit?
are in evidence stage, man.
Both are evidence.
Both are in evidence stage.
Yes.
Respondent. The
Let
grievance
it,
in this matter,
no, let it be clubbed wins. No.
only one submission to be made. My suit was filed initially. In fact, it was his own brother, thereby relationship, their brother. He was provided with the permission to occupy my property. It is a self-acquired, my absolute property. And I seek for possession of my, and in fact, I have to seek a declaration possession because I don't have a formal agreement of, with him. And this suit is instituted in Bangalore. And after the filing of the suit for possession, he comes and files this particular partition suit in Chandrayapatna just to stall my proceedings in for possession of my own property. And very importantly, two significant points is, his suit is a subsequent suit. At the time of filing of the suit also, he is a resident of Bangalore. According to him, one of the items are in Bangalore. If these bona fides were there, he would have presented the suit in Bangalore itself along with the suit and tried it along with the suit.
No,
He
no.
goes to Chandrayapatna and files a suit over there.
No, correct. Now, in the partition suit,
Yes,
there
please.
are other items also.
There are several other items, other properties, other parties
So
involved.
this suit will have to wait till then.
Yes, because he wants my possession suit to wait till he decides in the partition final decree.
But
That's
you
not
can't-
possible.
No, that you can't do anything. Let it go there. Let it be clubbed. Look at the issue framed. There's an overlap in issue.
Overlapping of issue, the issue if it is a common in the subsequent suit,
I
and
see.
section 10, the subsequent suit, and the partition suit is an elaborate inquiry. Until it is decided, I won't get the possession of my property. And if at all there was bona fides, that suit has to come here rather than where the
No.
subsequent suit has been
No,
filed.
that's a different matter. Now that you can always file separate CP. Now the only thing is we'll transfer it to that court because the overlapping of issues. Then it's a
My
leave it-
humble submission is, mine is a suit for possession which is pending. Now elaborate other issues are involved in that particular suit, parties are different, schedules are different. Until a partition suit is decided, it's going to be long standing. I'll be deprived of the, let him be, he's not paying any remuneration, he's using my property for free. Now he thinks by filing a partition suit, he can stall this proceedings till the ultimate partition suit is.
No, but now you go to the issues.
Yes, please.
Page number 47, my lord.
I'm not in dispute to the fact whether it's a joint family property, the issue has been framed in respect of that, whether it's my absolute property.
Now this 26392
Yes, please.
is the suit for eviction.
Yes.
Issue 4 is whether the defendant proves is joint family property of
Yes.
or ancestral property.
Yes, please.
Now the partition suit issues are at page
Page 47, my lord.
page 47.
Issue number 3, my lord.
This is item number.
Schedule, item number 1 of B schedule. Yes. B schedule property.
So it has to be tried together only because the overlapping of.
Now, only submission is, what is the legal implication if he intentionally goes, he is a resident of Bangalore also. He goes to Chandrayapatna and files a case because I filed a case here. He files a section 10 application in my suit, which is rightly rejected by the trial court to stop my proceeding. After he fails, he files a CP. The motive is very clear. He wants to stall my proceedings until the entire partition suit is disposed of. Now, what is the legal implication, my lord? Under section 10, if the matter is an issue in an earlier suit and the same issue arises between the parties in a subsequent suit, the subsequent suit will have to be stayed trial. Instead of that, the reverse is happening in this case, where he is able to stall my proceedings and not allowing me to take possession of my own property until a partition suit is decided. It would not be reasonable or fair
So
to.
we can't have a contradictory adjudication if both suits are at the stage of evidence.
No, I have started my evidence in my case. In this case, he has not started his evidence. Issues are in respect of other scheduled properties.
Matter is posted for evidencement.
Otherwise, you give an undertaking that you will wait till the outcome of the partition suit and then take proceedings.
It will have the same implications. It will have the same.
No,
implications.
if you say so, we'll record it and let the partition suit conclude till a finding on issue number 3 is recorded. You'll have to defer.
No,
That's
my apprehension is that is inordinately delaying the partition proceeding cannot deprive me of the possession of my own property until then. The
But
subsequent suit has to be, in fact, the trial in the subsequent suit cannot.
But
go.
that is a comprehensive suit, so you'll have to wait. In
No,
light
it's
of-
filed subsequent to my proceedings.
No, correct, but
I
look at
only
the-
to obstruct this.
but the relationship of parties requires that.
Then both the parties being in Bangalore, at least that let the matter be
That-
posted, let
that-
them at least consent for that. Let
That'll,
it come to Bangalore.
that'll keep it open for you to file separate CP, let the court decide. The petitioner. Ian Mohan Kumar has filed the present transfer petition seeking for withdrawal of proceedings in OS 26392 of 2018 pending before the court of the city civil judge at Bengaluru, filed by respondent herein Sri A.N. Shivalinge Gowda, seeking filed by Sri Shivalinge Gowda against the petitioner herein, seeking relief of declaration with respect to the property bearing number 424, first D main, 8th block, Kormangala, Bangalore 34, and directing the petitioner herein to quit, vacate, and deliver vacant possession. Full stop. Other reliefs are also sought relating to mean profits and damages for use and occupation of the scheduled property till delivery of vacant possession. Petitioner is sought for transfer of such proceedings to the court at Chennarayapatna, Hassan district, where proceedings in OS 107 of 2018 filed seeking partition is pending. Full stop. It is submitted that in OS 107 of 2018, the petitioner herein is the plaintiff in the said suit and the respondent in the present proceedings is the second defendant. Full stop. It is submitted that in the said suit, item one in Schedule B is the same property which constitutes the subject matter of OS 26392 of 2018. And in light of overlapping of issues to avoid passing of conflicting decrees, proceedings may be transferred as sought for. Next, learned counsel Shri Anil Kumar appearing on behalf of the respondent submits that the suit for ejectment filed by the respondent in OS 26392 is a suit that was filed at an earlier point of time, and that the proceedings in the ejectment suit cannot be dragged till conclusion of OS 107 of 2018. And even under law, the decision taken in an issue at an earlier point of time would bind the subsequent court. Accordingly, it is submitted. The question of transfer of the proceeding does not arise. Next, heard both sides. Perusal of the plaint in OS 26392 of 2018 and 107 of 2018 would indicate that the present petitioner is the plaintiff in OS 107 of 2018 and the defendant in OS 26392 of 2018, while the respondent herein is the plaintiff in OS 26392 of 2018 and the second defendant in OS 107 of 2018. Next, it is to be noticed that in the suit for ejectment, that is OS 26392 of 2018, the scheduled property is described as property number 424, first D main, 8th block, Koramangala, Bangalore 34. The same identical schedule with the boundaries is found at the schedule described in OS 107 of 2018 as item 1 of schedule B. Such identity of schedule, such identity in the schedules is not in dispute. A perusal of the issues framed in OS 26392 of 2018 would indicate that issue number 4 relates to the nature of suit scheduled property as being joint and ancestral property. Issue number 4 in OS 26392 of 2018 reads as follows, page 29, fourth issue. On the other hand, the issue framed in the suit for partition at issue number 3 at page 47, annexure F, reads as follows. If that were to be so, clearly there is an overlap in the issue number 3 in OS 107 of 2018 with the issue number 4 in OS 26392 of 2018. In order to avoid conflicting findings to be recorded on the said issue regarding nature of property and noticing that the relationship of the petitioner and respondent is that of brothers, and also noticing the defense taken in the ejectment suit that the property is a ancestral and joint family property, it would be appropriate to allow the transfer petition, and accordingly the proceedings in OS 26,392 of 2018 are withdrawn and transferred to the court Prime OS 107 of 2018. Third counsel appearing for the respondent submits that the question of no, I leave it at that. Now, if you want, you have.
That, my lord. Only one apprehension, only on grievance that the respondent would have is, this is a tactic to unendingly delay bringing and coming partition suit process. Justice would be done if my lord could kindly fix a timeline for completion. Both, this is justified both the parties. Some timeline for completion. Otherwise, these kind of tactics of obstructing judicial process by filing a subsequent suit, seeking transfer of the earlier suit.
The suit for partition pending to be expedited, the proceedings in OS 107 of 2018 to be expedited, taking note of administrative instruction issued for early disposal of suits relating to the year 2018. I'll refer to that administrative. Accordingly, petition is disposed.
Serial number 4, Mahesh Kiran Shetty, Omkar KV.
My lords appearing for the petitioner, kindly pass over the matter.
You have settled it. Is there any settlement?
Yes, yeah, my lord. Transfer petition it is.
No, correct. There's a observation that you will try to settle it, isn't it?
Yeah, my senior is in another.
Pass over.
5, S.V. Prakash.
Petitioners, my lord. My lord, there were two suits, my lord. One filed by the petitioner and another filed by the respondent, my lord. My lord, the with common judgment, my lord, the trial court, my lord, decreed the suit in respect of injunction is concerned. However, my lord, declined to grant declaration. Suit is for declaration and permanent injunction, my lord, against which I am claiming the declaration and permanent injunction to an extent of 1 acre 27 guntas, my lord. My lord, the respondent here in my lord claiming claiming declaration and injunction to an extent of my lord to.
We'll pass over, let him come. We'll dispose it of.
Please, my lord.
Pass over. Just see where he is. Whether in Dharwad or here or Kalburgi, I don't know. Find out, find out. I think he's gone. Kalburgi is government. Huh?
My lord, kindly have it some other day, my lord.
Correct. You'll find the same difficulty even some other day. So you collect the phone number
please,
and
please,
find
my
out.
lord.
We'll have it on Tuesday.
Please, my lord. Please.
We'll list the matter on Tuesday. So I think he's a government advocate in Kalburgi. Just find out.
Please,
so
my
what
lord.
arrangement he'll make?
Please,
whether
please, please, my lord. Interim order may kindly be extended.
Earlier grant is extended till the next date.
6, Rajendra, yes.
My lord, I appear for petitioner, my lord.
Yes.
This is a wife petition, my lord. Transfer of MC petition pending before the family court at Mysore to family court at Bangalore.
Wife's petition.
Please, my lord. My lord, the marriage solemnized on 1/7/2020. My lord.
Dispose again. 13B petition is filed and disposed of. Case status. So we'll dispose it of. They've given the extract of the. It's settled in mediation itself. The present petition has been filed seeking for withdrawing the proceedings filed by the respondent against the petitioner under section 9 of the Hindu Marriage Act in MC 846 of 2022 and transferring the same to the court of the principal judge, family court at Bengaluru. He submitted that the extract of from the website relating to case status reveals that MC 846 of 2022 has been disposed of as settled in mediation. In light of the same, the relief sought for in the present petition does not survive for consideration and is disposed of as having become infructuous.
Much obliged. 7. Prakash DC.
I pay for respondent. I pay for 2 weeks accommodation to file my. Notice it is for evidence.
No, now what objection you'll file in CP matter? Why you have to keep it pending? Let that side or this side, let it go, let it be disposed of.
Next week, my lord,
Next week I'll have it.
file my objections.
What objection you can have in CP matter?
My lord, this is not a section 13 matter, my lord. This is a petition under section 12(1)(A). So, my lord, there are several allegations even against the.
Correct, but we are only on the point of where it has to be tried, isn't
Please,
it?
my lord.
Not on the merits
Even,
of.
even, my lord, the petitioner is not seeking this matter to be transferred to the nearest court at her residence. My lord. She is seeking to the other court. It is only with an intention to disturb the petitioner, disturb the respondent, my lord. So that let me brought to the notice of the court, my lord.
You are even otherwise disturbed now.
Please, my lord. That is what exactly, my lord. Let me bring it to the notice of this.
I'm saying unless the main dispute is settled, there is no relief.
My lordship, I am appearing behalf of petition counsel motion. He's taking, yeah.
We'll have it on Tuesday. Get ready.
Next week, my lord.
Correct,
I'll
next
have to
week.
file my objections. So,
What objection, counsel?
lord, let me come up with few documents.
Now, in the CP matters,
Please,
the
I
wife,
understand.
wife always prevails as usual.
I understand.
At your home also,
But, my lord,
at everybody's home also.
if there is any, if there is
That
any
you place in case,
suppression of material fact, my lord,
that you point out.
please,
We'll have it on next Thursday.
please.
My lordship, petition counsel requested me to pass over the matter, my lordship.
Now let us see, he wants to file something. Interim order earlier grant is extended till the next date. This is the matter on next Thursday.
8.
Interim order earlier grant is extended till the next date.
For petition number 8.
Kindly pass on.
For the respondent.
Transfer petition.
So what has happened? The mediation failed.
Mediation has failed.
Huh?
Yes, mediation failed, madam.
So where?
This honorable court directed the petitioner to produce those documents. She stated in the petition, she is studying BCom in Bangalore. This honorable court directed the petitioner to produce those documents. Thereafter, my lord, in the last date of hearing, they have produced the documents stating that she is studying online education.
She's staying, where is she staying?
Staying at Bangalore.
She's staying at Bangalore. Then you produce it, let him have a look at it. Now you are seeking for transfer from Chandrayapatna to Bangalore.
Bangalore.
Now, according to you, are studying in Bangalore. Staying.
Her place is Carpet, my lord. It is 15 kilometers from Chandrayapatna. But for the sake of study, she is residing in Bangalore. She stated in their petition.
Now you produce that, what is the document to show that you are studying in Bangalore? Let's take it.
It has been produced, my lord.
File.
It has been produced, my lord. Kindly pass on.
They have filed, my lord.
We have
The
filed
last date
already
of hearing,
filed.
they have produced those documents, online
File been
education.
But she has filed also rent agreement.
Rent agreement, madam.
In the second document in the memo.
Yes, madam.
At Bangalore.
There are BCom colleges in Carpet and Chandrayapatna also, my lord.
No,
But
correct,
she
correct,
stated in.
Studying in final year, my lord.
He's studying in Bangalore, then it will have to be transferred.
No, my lord. This is the University of Jaipur, my lord.
No,
Manipal
correct.
University of Jaipur.
Lease agreement.
She's staying at Bangalore.
Lease agreement. That you want to find out, you find out what is the. If you want to find out about the veracity of the document, you find out, we'll have it next week. Now, petition is filed on 23rd March.
Yes.
Lease deed is entered on 25th of February. If you want to find out, you find out. You can make investigation and find out. If it is so, then it will have to be allowed. But if there is some doubt, we'll consider. When do you want? Relist the matter on 7th.
Nine, Kirti Prasad KC, Venkat Reddy.
Petition. See, from the day, so they have not consummated. So main allegation is that she is a doctor. After knowing fully well, the marriage was celebrated with the cost of the respondent's parents.
So correct, we are now only on the point of transfer, isn't it?
So transfer cannot be done because of various reasons.
Yes, let him come. Oh, yaar hesaru nodu?
Kirti Prasad.
Huh?
Ashok.
We'll have it next week and then decide, we'll see. Now, they're seeking transfer from where to where?
So from Bangalore to Tumkur. Bangalore, from the day she has not coming to the house of respondent husband.
For the
So
petitioner.
from the first day itself.
No, that is on merit, sir.
Yes.
Only on the point of transfer.
So transfer, she is able to come and adduce evidence. The term, your lordship fix the time bound limits. We are ready to go on with the matter. We are also trying for the settlement also.
So we'll transfer it and then ask them to expedite the hearing on the main matter.
Here only minutes within us, we are undertaking that we will not.
You are saying they want it there, so something will have.
So that there is no any ground, so there is no single ground to transfer.
We are following the judgment. We are following the judgment in Rekha's case. That says the convenience of the wife must be taken.
Not only convenience, it is unable to come and so whether she is disabled or any disease or unable to come.
The court has said convenience of the wife. That's the law. We are following in all matters.
Look, convenience is, it is only a 60 kilometers from here to there. And from the day, so they have spending more than some huge money for.
So let us see now. If both of you want to settle it, I can adjourn it. Otherwise, you must go.
We have tried in the last again the.
Correct. So it's better that the case on its merits moves on, whether here or there. Otherwise, you'll get caught in this unnecessary years together in these proceedings. Now, suppose it's not possible to come together.
Yes.
The only alternative is the proceedings at least must conclude at the earliest so that you can.
So that is going on.
Correct. Now they want it there. Go and do it there only from the same state.
So here only, so let the time may fix 2 or 3 months.
That we can't do. We can't do that.
That we will. So kindly adjourn by 2 weeks. In the meantime, we'll within 1 or 2 weeks, there is a case in divorce case before the family court. We will try. In the last occasion, my learned friend also saying that we will try.
Your lordship, a mother of the petitioner is suffering from cancer. She can't travel to the Bangalore.
So why they have?
That is, no, just 1 minute. Now that is on merit, sir. You want to settle it, I'll give it time or I'm going to dispose it. Is there any chance of a settlement? We'll see.
If there are any settlement, let it happen there itself, your lordship.
So we are ready. So because.
No, I can't force. That's between you both that you do it, we'll see.
So in the meantime, when judgment is there, if the Supreme Court, I will bring my lord.
Considered everything and passed. I've considered everything and passed. In this CPL, argument.
Argument see, our inconvenience and also inability to come to because it is only 60 kilometers.
I've considered all.
So it is in all way it is possible to complete the entire proceedings within 2 or 3 months. So we are ready. So if the settlement is not going on.
I've considered everything. We'll see. The petition.
So kindly have 2 weeks, my lord, so that the judgment I will. So if
I've considered everything and passed in civil all Supreme Court judgments I've considered. in CP 154 of 2020. And then I'm following the coordinate bench's judgment. All points, there's nothing in CPs anymore that is left open. for
If
consideration.
she has not in a position to come here, then so what inconvenience they have to come here and.
That we'll consider. Yes,
Sir.
what is your case?
Your Lordship, the mother of the petitioner is suffering from cancer.
Yeah.
So she cannot travel to Bangalore frequently, Your Lordship.
Have you produced records to show that?
I'll produce in the next date, Your
You
Lordship.
have to produce it, isn't it?
Yes, Your Lord.
You are working or what?
Yes, working, Your Lordship.
Where?
In Tumkur itself, Your Lordship.
She is a doctor. So now knowing fully well at the time of performing marriage with all consent, they have shifted to Bangalore and work here.
Let us see. You produce that. Relist the matter on next Thursday.
2 weeks.
ಏನಾಗುತ್ತೆ ಇದರಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಪೆಟಿಷನ್ಸ್ ಅಲ್ಲಿ ಏನು ಆಗಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ must take place on its own. Let us release the matter on 7th.
Much
The legal position is clear, Mr. Reddy. That certainly, unless you settle it amongst yourselves.
That is too much. Is there any inconvenience to come?
That let us see. We'll consider
So
that.
if really inconvenience, we will also consider to.
Now you produce the medical.
I'll produce it.
Uh,
I'll produce.
Yes.
Much of it.
7th, 8th.
8th. 11th, 12th. 11th.
11th ಗಿಂತ 12th ಹಾಕೊಳ್ಳೋದು ಒಳ್ಳೆ.
12th.
12th.
December 11, case donation.
12th.
For the petition, my wife seeking transfer of the MC Patna.
Your voice is breaking.
The respondent filed a divorce petition.
Yes.
This petition is by the wife, my lord.
The two
Seeking
petitions.
transfer of MC from, yes, both are sisters, my lord.
Sisters and brothers, my lord. Petitions are the sisters and
Correct, but
respondents.
why have you clubbed the case? They are otherwise already done. Don't make it more complicated.
Sent to mediation center for settlement, my lordship, and settlement is not arrived by the parties.
ಇಬ್ರಿಬ್ರದ್ದು ಯಾಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, two
ಅಲ್ಲ,
petitions.
ಎರಡನ್ನೂ ನೆಲಮಂಗಲ್ ಹಾಕಿದ್ದಾರೆ. ಸಪರೇಟ್ petitions. ನೆಲಮಂಗಲ್ ಹಾಕಿದ್ದಾರೆ. ಅದನ್ನ we are seeking transfer of it to the Piriyapattna, my lord. That's all.
The husbands are filed the petition before the court at Asan for seeking restitution of conjugal rights under
Then,
Section 9.
we'll deal with it separately. Let's not club issues.
Yes, please, please.
First, 316.
Yes, my lord.
So now the petitioner is
Out of the wedlock, yes. Out of the wedlock, there are two sons, my lord. Now, the petitioner is not working woman.
aged
And
about?
she has no independence. Age about 7 and 2 years. Children's age about 7 and 2 years.
She is not working.
No, my lord.
Husband, they residing at
He
Bangalore.
is in residing in Nagasandra, my lord, Bangalore.
We'll transfer it later.
I make one submission. I permitted to appear through video conference also.
Yes,
my lord.
yes.
That liberty is reserved, my lord.
Yes. ಅದೊಂದು ಚೆಕ್ ಮಾಡ್ಬೇಕು ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ವರ್ಕ್ ಆಗುತ್ತಾ ಅಂತ. Section ಹೋದಾಗ though it is required, some places they have that, but I will give that.
Yes,
I'll
yes, ma'am.
mention. Except in COVID times, after that even the courts are not, in some places it is still functional. CP 316 of 23 is delinked and taken separately. The petitioner, who is the wife, has sought for withdrawal of the proceedings in MC 157 of 2023, pending on the file of the Principal Judge Family Court at Hassan, and has sought for transferring of the same to the Family Court at Patna. It is the case made out by the petitioner that from within the wedlock entered into on 22/1/2015. Petitioner and the respondent have two sons aged about 7 and 2 years. It is submitted that petitioner is not an earning member and is a dependent on her parents. It is submitted that as the petitioner stays at Patna, traveling to attend traveling to attend proceedings at Hassan in MC 157 of 2023, which involves travel of
100 kilometers.
100 kilometers.
Of about 100 kilometers causes serious inconvenience, more so in light of the younger son who's aged about 2 years. He cannot be left alone. Next, learned counsel for the respondent opposes the petition. Heard both sides. Next, taking note of the admitted facts that the petitioner and the respondent have 2 children from within the wedlock who are aged son and daughter, is it?
As per my information, both are sons, my lord.
Correct, but name, just look at the name.
ನಾವು ನನಗೂ just I looked at but ಅವ್ರು ಹೇಳಿದ ಇರ್ಬೇಕು ಗಂಡ್ಮಕ್ಳು ಅಂತಲೇ ಪೂರ್ವಿಕ ಅಂತ ಇದೆ but
2 children ಅಂತ ಹಾಕಿ sons ಬದಲು. Taking note of the admitted fact that the younger child is aged about 2 years and that the distance between Patna and the court at Hassan is about 100 kilometers. The assertion of the petitioner that there would be inconvenience as the younger child cannot be left at home while traveling to attend case at Hassan, which causes inconvenience, requires acceptance. In light of the law laid down in V. Rekha's case, as the Manjana. In light of the law laid down in MV Rekha versus Satya alias Suraj, ILR 2010 Karnataka 5407, it would be necessary to take note of the wife's convenience while considering petitions for transfer. Para 15, the said judgment reads as follows. Next. Accordingly, case is made out for allowing of the petition and the procedure. Full stop. Next, in so far as the inconvenience of the respondent is concerned, it is submitted that the respondent may be permitted to avail appearance through video conference as and when practicable. Full stop. Accordingly, the court to which the proceedings are transferred to take note of the video conference rules so and so and permit the respondent herein to participate in the proceedings through video conferencing facility as and when practicable without insisting physical presence on all days. Accordingly, subject to the above observations, petition is allowed. The petition in MC 157 of 2023, pending on the file of the Municipality Family Court at Hassan, is withdrawn and is transferred to the designated Family Court at Piriyapatnam. Accordingly, petition is disposed of.
If they desire to settle the issue, then the court will permit it to settle the issue, my lordship. They want to settle the issue, that observation could be made, my lord.
Needless to state
It is always open.
that it would be appropriate for the court to also explore the possibility of settlement between the parties once again. This connected matter, we'll have it next week, let us see.
Same, my lord.
ಅಲ್ಲ ಅದಕ್ಕೆ ಬೇಡ ಅಂತ ನಾನು ಹೇಳೋದು. It will become more
ಆಗ್ಬೋದು.
complicated. Let there be some gap. Otherwise, both lives will go. That's a very sad state of affairs. So we'll at least let's see. We don't know in which matter actually there is some trigger. Now both why you want to. It cannot become a war. Then both of them will be lives.
Both are separate petitions. Separate petitions.
Separate petition filed by the brothers, my lord.
Correct, but now everything is clubbed now. Literally and otherwise also. We'll have it on next
Date may be
Tuesday.
given.
We'll have it
Date
on
may be
Tuesday.
given.
Any date convenient.
Release the matter on Tuesday.
Much obliged.
Now
Obliged.
try and see if it can be settled.
Make our maximum efforts, my lordship, but
But the parties are stick to their stands.
the petition not.
That's why it is not possible.
Parties are okay, their parents, some problem will be. Because one relationship is spoiled. Now there'll be pressure that other also.
That is the problem, my lordship.
We'll try our best.
Let us.
Obliged, man.
Serial number 12.
A paper, petition of- why petition, petition, my lord.
Next time, fresh matter is available.
Why petition seeking transfer to Chitradurga to Bangalore, my lord? My lord, the husband has filed the petition before the.
Yes, what are the facts?
My lord,
What
the
are the facts?
respondent has filed the petition under section 13(1)(a), 1(b) before the family court of Chitradurga, my lord. First edition of senior judge Chitradurga. The respondent, the petitioner wife also filed one petition before conjugal rights petition, MC 4427 of 23 before the third edition of family court Bangalore, my lord.
Annexure?
My lord, annexure B, my lord.
Annexure?
Annexure C, my lord. D, sorry.
4427.
Yes, my lord. My lord, the husband petition, the caste title address, my lord. Annexure B, the presently residing is staying in Bangalore, my lord.
Annexure?
B, my lord. In caste title address, my lord, the petitioner address presently stayed in Bangalore, but it
Petitioner.
intent arrived to the.
Petitioner. Any of both have to be tried together only.
Please.
The petitioner. Who's the wife? Has sought for withdrawal of the proceedings in MC 116 of 2023, pending before the first additional senior civil judge Chitradurga. And has sought for transfer of the same to the family court at Bengaluru. From the admitted facts, it comes out that the petitioner and respondent had entered into a wedlock and subsequently differences of opinion have crept in the relationship, leading to breakdown of the relationship, and the petitioner has filed MC 4427 of 23 against the respondent herein seeking for restitution of conjugal rights, which is pending consideration before the family court at Bangalore. While on the other hand, the respondent husband has filed MC 116 of 2013 of 2023 seeking for dissolution of the matrimonial relationship under section so and so. The section ange barkoli. Nature BL. Seeking for dissolution of the matrimonial relationship. The said proceedings are pending before the court of the Principal Senior Civil Judge at Chitradurga. In order to avoid passing of conflicting orders, necessarily proceedings for dissolution of matrimonial relationship in MC 116 of 23 must be tried along with the petition filed under section 9 of the Hindu Marriage Act pending between the same parties in MC 4427 of 23. Insofar as the situs of the litigation is concerned, while it is noticed that the petitioner wife has instituted proceedings for restitution pending before the family court at Bangalore, it is also noticed from the cause title in MC 116 of 2023 that the respondent herein, that is the husband, who is the petitioner in MC 116 of 2023, also stays at Bangalore. Accordingly, in light of the admitted facts, in order to avoid passing of conflicting decrees, also taking note of the convenience of the wife, the petition is allowed. The proceedings in MC 116 of 2023 is pending before the court of the first additional senior civil judge at Chitradurga, drawn and transferred to the family court at Bengaluru, in which MC 4427 of 2023 is pending, with the further direction that after withdrawal and transfer, taking note of the nature of proceedings in both the pending matters, both may be clubbed and decided simultaneously. Accordingly, petition is allowed.
13, Jay Kumar, Sridhara.
Appear for the respondent.
I am for the petitioner.
Matter is ready to settle. ಒಂದು ಮ್ಯಾಟ್ರ್ ಸೆಟ್ಲ್ ಆಗ್ತಾ ಇದೆ. ಟೈಮ್
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ, ಕ್ಲೀನ್ ಆಗ್ತಿಲ್ಲ, ಆಗಿಲ್ಲ.
ನೋಡೋಣ.
ನಾವು ಟೈಮ್ ತಗೊಳ್ಬೇಕು, ಮಾಡ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. ಏನಂತಂದ್ರೆ
ಸೆಟ್ಲ್ ಆಗ್ತಾ ಇದೆ, ಅವ್ರು ಮಾತಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ನನಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂದಿಲ್ಲ. ನಿನ್ನೆ ನಾನು ಹುಡುಗಿ ಫಾದರ್ ಜೊತೆ ಮಾತಾಡೀನಿ ಸರ್. ದ ಚೈಲ್ಡ್ ವಾಸ್ ಬಾರ್ನ್ ಆನ್ 11/8/2021. Still date, he has not visited to see her daughter, baby girl. ಅವರು ಫಾದರ್ ಬಂದು ಟೀ ಅಂಗಡಿ ಸ್ಟಾಲ್ ನಡೆಸ್ತಾ ಇರೋದು ಕೆರೂರಲ್ಲಿ. ಇಟ್ ಈಸ್ ಫಾರ್ ಅವೇ ಫ್ರಮ್ ಬೆಂಗಳೂರು, 600 kilometers ಇದೆ. I have called up, mediation ಆಯಿತು ಇಲ್ಲಿ. He is not cooperated. Even he is not talked to her daughter also. ಇದು ಸುಮ್ಮನೆ ಇದು ಮಾಡೋದು. ನೋಟಿಸ್ಗೂ you just go to the notice, your lordship, at page number 12, ink page number 12. He is making a bald allegation on the girl, and then he has filed this restitution conjugal petition, only to harass, because her father is running a tea stall. Till now, the matter was came before this court on 13 August 2023. I have got interim order. I have waited till date. They have not come forward to see that girl also. Then yesterday I have moved memo, because her father called, they are not
coming forward to get the wife and that girl. That is why they want to proceed with this petition transfer to Badami court. They will, it is in the 20 kilometers from her native place. He is an employee, he is earning about 70 to 80,000 rupees. He is staying in Bangalore. He is a native of Gajendragad, which is near to petitioner's place.
Now he wants you, he wants your client. He wants
Whatever,
you-
let them give proposal, sir. Before this one, let them
I
give
will
proposal.
present before this honorable. Ready ಇದ್ದಾರೆ ಆ ಅಮ್ಮ ಬರ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದಾರೆ. ಸ್ವಲ್ಪ
ಅಲ್ಲ ಇವ್ರು ನಾಳೆನೇ ಹೋಗಿ ಕರ್ಕೊಂಡ್ ಅಂತ ಹೇಳ್ಬಿಡಿ, ನಾನು ಕಳಿಸ್ತೀನಿ.
ಒಂದು 10 days ಅವತ್ತು
ಅದಲ್ಲ, ನಾಳೆನೇ ಹೋಗ್ಲಿ ಅವರು, ನಾನೇ ಹೋಗ್ತೀನಿ ಬೇಕಾದ್ರೆ.
present before this honorable court. ಒಂದು 10 days time ಕೊಡಿ.
Relist the matter. Next week I'll fix a day.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡ್ಬಿಡಿ ಸರ್. ಸ್ವಾಮಿ ಈ ವಾರ ಹೋಗಿ ಬಂದ್ಬಿಡಿ ಪಾಪ.
ನೀವ್ ಅದೇನ್ ಡಿಸೈಡ್ ಮಾಡ್ತೀರ
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಕಳಿಸ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೀನಿ. ಇವನ್ ಅವ್ರ ಪೇರೆಂಟ್ಸ್ ಹೇಳಿದ್ದಾರೆ, ಇವ್ರು ಹೋದ್ರೆ ಸಂಡೇನೆ ಕಳಿಸ್ತಾರೆ. ಸಂಡೇ ಆಸ್ಕ್ ಹಿಮ್ ಟು ವಿಸಿಟ್ ದಿ ಕೆರೂರ್.
ರೆಡಿ ಇದ್ದಾರೆ.
ಅಲ್ಲ
ಬರ್ಲಿಕ್ಕೂ ರೆಡಿ ಇದ್ದಾರೆ, ಅವ್ರು ಜಾಯ್ನ್ ಆಗ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದಾರೆ.
ಸರ್, ಹುಡುಗಿ ಮನೆ ಹೋಗ್ಲಿ ಸರ್, ನಾನು ಅವ್ರ ಫಾದರ್ ಹೇಳ್ತೀನಿ, ಕಳಿಸ್ಬಿಡಿ ಅಂತ ಹೇಳ್ತೀನಿ. ಕೇಳಿ ಸರ್, ಹೋಗ್ತಾರೆ ಸಂಡೇ ಕೇಳಿ. ಅದರ್ವೈಸ್ ಮಂಡೇ ಯು ಕ್ಯಾನ್ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್.
Then you go and visit their house.
ಸಂಡೇ ಹೋಗ್ಲಿ ಸರ್, ಸಂಡೇ ಹೋಗ್ಲಿ. ಹೋದಿದ್ರೆ ಮಂಡೇ ಮಾಡೋಣ. ಮಂಡೇ ವಿಲ್ ಗಿವ್ ದ ಪ್ರಪೋಸಲ್.
Relist the matter.
On Monday.
Next Wednesday. Meanwhile, you just see now he is ready. He will.
ಸರ್, ನಾನು ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ಸರ್, ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ.
He will advise his client. If something good comes out, best for everybody.
ಸರಿ ಸರ್.
We'll have it on next Wednesday. Okay, no.
14, R. Kiran, Bimbadar,
Respondent.
R. Kiran.
My lordship, I am appearing for the petitioner counsel, my lordship. Petition counsel is not in a station, my lordship. Kindly have this matter from Monday, my lordship.
Monday.
Fifteen, Prasad B.S.
Petition.
Before the
So
respondent.
wife petition, my lord. Husband filed a divorce petition in a Hunsur court, my lord. Wife residing in Udyavara, Udupi jurisdiction, my lord. She is having 4-year-old kid. Traveling is concerned, my lord, more than 9 hours from Udyavara to.
How many kilometers?
It's nearly
250 to
250
275 kilometers approximately.
And a 4 years kid is there, and he's not giving maintenance also.
May I make a submission? I've
Yes.
filed
There
my-
was-
I've filed my objections, have stated the respondent's parents are not well. His father has undergone a surgery recently in Shankara Cancer Hospital. And they have this medical issues from last 3 years. And he is running a shop, small coffee powder shop in front of the house itself. And he cannot leave the place. He is the only son, and his sister is in Bangalore. She cannot also come over there since her children are studying in 9th and 10th standard. So 10th standard is a turning point for her children. She cannot come from Bangalore to Hunsu. And he is the only person who has to take care of. It is not like any other health issues, my lords. Her father is suffering from osteoporosis and recently was diagnosed with cancer, and he has recently undergone a surgery, and I have produced a document. And her mother, his mother is suffering from this bone bulge in the L4, 5, 6. She has to undergo a surgery, but success rate is very low. So she is taking treatment, Ayurvedic treatment. And she is she cannot help her husband also. He is the only son.
I'll consider. Now the fact that he is married, he has to accommodate all.
My
can't-
lords, it is not that. Many mediations have done and they
Correct,
have
that's,
met.
that is on merit, sir. But
But-
now we are on the only point of transfer.
Yes,
No
my
doubt
lords.
you have difficulties, but comparative hardship and then
No, she
whatever.
can travel. It is hardly 250 kilometers. Her only hardship is traveling, my lords. But he cannot leave his parents.
Correct, she also will
Because-
have,
No,
she'll also have same difficulties, man.
No,
You can't-
she is, by God's grace, she is healthy. She can travel. She has no other adults. A child can be under the care of
But the law,
parents.
the law is different.
Please,
Law
my lords.
says,
Please, Mas, I can understand, but there is a exception for every rule, my lords. Because once He cannot leave his father for a day also. He has to do every entire thing. Like from personal care has to be taken care. He
Yes,
cannot
what-
move.
Yes, what do you say?
Harassment, my lord, is a
That is on merit, my lords.
What is the age of the child?
child 4 years. So one time they said that, my lord, in mediation center, there
We are
is
ready.
so many objection.
We are ready.
And
Huh?
kindly see, my lord. So,
You are-
Let him-
Just
So-
a minute. You are ready to?
We are ready to take her back, my lords.
Why they filed a-
Two
they-
mediations,
Just wait.
two mediation went on. Even presiding officer herself has done a mediation. She conducted a mediation. She says, I'm ready, but she is not ready to come immediately. She wanted her mother-in-law, she doesn't want to live with her mother-in-law. Respondent stated that he is ready to take her and in a separate residence to set up a separate residence. Then also she is not ready.
Yes, what do you say?
Mediation
Withdraw
filed,
the
my lord.
petition, my lord. If that is so, divorce petition, withdraw the petition, divorce petition, then they can
My
join.
submission.
Yeah, but this, they are saying that, my lord, in the
No, let
mediation
it-
center also.
No, correct. Now, if they're ready to take her back, then where is the problem?
I have no problem because he says that, my lord, he will keep her in the separate residence. And his, since from the beginning of marriage, he's doing the very same. And he keep in separate residence and left away from that place. Because I am residing with the parents, anyway, I am ready to take care of their mother-in-law and father-in-law. They are the fag end of his life. I am ready to take that one also.
That's not
But it's not possible because that type of harassment, he's having a illicit relationship with some other. And that's the reason, my lord, one or the other way, he is dragging the issue. If that is so, my lord, if it is a real intention, he would have not filed a divorce petition. He would have filed a restriction of conjugate. And not only on marriage, my lord, so many difficulties there. Even then, I have not disclosed each and everything before this petition. And one or the other way, my lord, he is harassing and he is not at all giving any maintenance also.
I may be.
And now, my lord, I filed a maintenance petition before the Udupi court. And 4 years kid is there. He is having a property, landed property, as well as a business is there. And he is not a layman.
Let us,
My submission is, I myself have issued a notice, I've talked to the client. She doesn't want to join. This is the fact. I'm with a conversation with the client. I personally took the interest stating, I called her personally, see, husband and wife, some issues may come and go. There is a child, please join your husband. Whatever you want, that will be provided. She has recorded my call also. She has recorded. Twice I called her, not now, in 2021, March. She has recorded my call and she stated, yes, you are done, but she's till date, she has not come back. She is not ready to join. Mediation filed, my lord. She wants money. She doesn't want to join her husband.
let us, the petition is filed by the wife. Seeking for transfer of the proceedings in MC 39 of 2023 in the file of the additional senior civil judge and JMFC at Hunsur and transfer the same to the family court at Udupi. This is the case of the petitioner, with the petitioner and the respondent had entered into a matrimonial relationship on 7/2/2018. And from within the wedlock, they have a female child who's aged about 4 years.
May I make one more submission? They are living in a community living. They are living with her paternal uncle and other persons are also living. It is not that only her parents have to take care of the child. That is has to be brought to your notice. Then in the Udyanavara Tota, it's Tota means it is in a community. Like 3-4 paternal uncles and brothers are living together, my lords.
It is submitted that the petitioner it's submitted that after differences of opinion have crept in, the respondent husband has instituted proceedings seeking dissolution of the matrimonial relationship in MC 39 of 2023 before in the court of the principal senior civil judge and GMSC at Hunsur. It is submitted that the distance between the petitioner's residence at Udupi and the court at Hunsur is about
250 to 270 kilometers approximately.
about 250 kilometers. And traveling such distance affects the education interests of the child, as well as it would be difficult to leave the child alone if the petitioner is required to attend proceedings before the court at Hunsur. Accordingly, petition has been filed. That counsel appearing for the respondent has filed a statement of objections to the petition and submits that the parents of the respondent are senior citizens and are suffering from medical ailments. It is submitted that the respondent's father is ailing from osteoporosis and his movement is curtailed and he needs support for daily in his daily routine activities. It is further submitted that the respondent's father has been diagnosed with a tumor in his neck and the same requires to be operated upon.
Already operated, recently operated in Shankara Hospital, Cancer Hospital.
And the same has been operated upon, which has led to dependence upon the respondent. It is further submitted that the counsel for the respondent submits that the petitioner staying along with other members of the extended family, and accordingly the child could be looked after by the extended family, and the inconvenience as made out is lesser compared to the inconvenience caused to the respondent husband. Next, heard both sides. It is not in dispute that the petitioner currently is residing at Udupi, and the court to which the petitioner is required to attend to defend the proceedings before the senior civil judge at Hunsur is at a distance of about 250 kilometers.
Approximately.
Full stop. It is also not in dispute that the petitioner and the respondent have a child aged about 4 years. Full stop. If that were to be so, attending matrimonial proceedings at the court at Hunsur by traveling and leaving the child of tender age alone is an aspect of inconvenience that has to be taken note of. Next, no doubt the respondent has also made out certain difficulties, such as need to look after aged parents. Moreover, where the father has medical issues. However, when both the convenience and inconveniences of the respective parties are balanced, it cannot be lost sight of that the distance to be traveled while attending cases involving matrimonial issues also imposes psychological stress on the wife and a need to look after the child of tender age who may not be in a position to be left alone. If taken note of, would result in the inconvenience of the wife being much more than the inconvenience of the respondent husband. Next, accordingly, case is made out and the petition is allowed, and the proceedings in MC 39 of 2023 pending before the court of the principal senior civil judge and JMFC Hunsur is withdrawn and transferred to the family court at Udupi. Accordingly, petition.
They make on submission, my lord. Time may be, direction may be given
Next.
to.
Once the proceedings are transferred, the proceedings in MC 39 of 2023 is to be expedited, taking note of the seniority of the petition vis-a-vis other matters pending.
Sixteen, 10.30.A. Harish Kumar.
I am for the respondent husband.
My lords, petitioners is the wife, my lords. She resides in Bangalore, my lords, and the husband had filed a petition in Mysore for transfer. My request, my lords, to kindly have page 29, my lords. There are no issues out of the marriage. The petitioner, my lords, has filed a divorce petition in Mysore, wherein, my lords, is given the address of the respondent as Bangalore. My lords, is about 135 kilometers, my lords, to be traveled. She is employed in Bangalore, my lords.
He is working.
She is working.
Where is she working?
My lords, that detail, my lords, I have not stated, but she is employed in Bangalore.
My humble submission is, my lordship. Respondent now he is in America, my lordship, USA, my lordship.
He is in?
USA, my lordship. You want to execute the SPA in favor of his father, my lordship. His father 70 years old, my lordship.
Then that cannot be a ground at all.
He is not able to travel from.
No, that is his headache now. It's the respondent's headache, how he is going to conduct it. Anyhow, he is abroad, so it doesn't matter whether it's in Mysore or Bangalore.
Then, my lords, matter already posted for petitioner evidence, my lords.
Huh?
Matter already posted for petitioner evidence, my lords.
That's okay. Now you have to, you are staying abroad, so how does it matter? You will have to undergo all these problems unless the main problem is sorted out. The present petition is filed by the wife seeking for withdrawal of the proceedings in MC 382 of 2020 pending before the second additional principal judge family court Mysore, and I sought for transfer of the same to the family court at Bengaluru. The petitioner submits. It is submitted on behalf of the counsel for the petitioner. The petitioner is working at Bangalore and accordingly attending proceedings before the family court at Mysore would involve travel of about 130 kilometers. And that apart, in light of the petitioner being employed, traveling frequently to attend the case may also threaten her employment itself. Accordingly, it is submitted that taking note of the inconvenience of the petitioner, petition be allowed. The counsel for the respondent submits that the respondent is currently staying in the United States of America. The only way of conduct of proceedings is by executing power of attorney in favor of the father of the respondent, who is a senior citizen, and accordingly it would be difficult to attend proceedings if the matter is transferred to the court at Bengaluru. Next. It is taking note of the distance between Bangalore and Mysore. Though traveling is not seriously an inconvenience, however, the fact that petitioner is also working at Bangalore, the assertion that traveling to Mysore to attend proceedings would endanger her, would threaten continuance of her present employment is a matter to be taken note of. The inconvenience of the respondent, insofar as respondent's husband is to conduct proceedings, cannot outweigh inconvenience of the petitioner's wife. Accordingly, petition is allowed. The transfer petition 382 of 2023, pending on the file of the Second Additional Principal Judge, Family Court, Mysore, is directed to be withdrawn and transferred to the Family Court at Bengaluru.
One submission. What?
Mentioning at 2:30.
ಯಾರಿಗೆ ಇವತ್ತಿಗೆ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಹೋಗಿದ್ರು ಹೊರಗಡೆ ಬರ್ಲಿಲ್ಲ. ಕಂಟಿನ್ಯೂಷನ್ 379 ನಿಮ್ಗೆ ಆಗಿದ್ದಲ್ವಾ? ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಇಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಅನ್ಕೊಂಡು ಕೊಟ್ಟಿದ್ದೀನಿ ಅದಕ್ಕೆ. ಹೇಳಿ. ಸರ್, ಕೇಸ್ ನಂಬರ್ 555 ಇದು.
Sir, first list 26.
ಇನ್ನೆರಡು ನಿಮಿಷ ಇದೆ. ಒಂದೇ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕಂತ. ನಾ ಅದಕ್ಕೆ ಅಲ್ಲೇ ಅನ್ಕೊಂಡು ಎಲೆಕ್ಷನ್ ಮಾಡ್ತೀವಿ. ಈಗ ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟ್ರ್ ತಗೋಬೋದು. ಒಂದೇ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ಈಗ. ಅರವತ್ತೆಲ್ಲ
My lord. Second list, item 41. It's an Admiralty matter. The vessel was arrested on 1st February. And a petition to vacate the arrest was filed on 21/2. There is a main IA to be heard. In fact, my lord, I will take some more time. And the council has now filed another IA for permitting the crew change of the cruise. And the vessel was shifted from port to outer anchorage. That IA we endorsed no objection. But both the IAs may be heard on Monday. Your lordship permit me at 2:30, any other day, convenient, your lordship at 2:30.
It requires some hearing, is it?
Yes.
I would say this, my lords, that I have sought for the raising of the attachment or the raising of the arrest, my lords, passed for your lordships. There is some extreme urgency for me. My lords, if your lordships could hear my part, my lords, today, and then for his part, if your lordships could take up this matter on Monday,
But today there's some election matter.
then because there is an extreme urgency is what I am pleading. If the learned senior counsel, my lords, it's convenient for him, otherwise, and your lordships on Monday, my lords. Monday, your lordships may fix it this matter at 2:30, and one indulgence at your lordships' hands, my lords, please give the application. Not the application for which the no objection is indicated is for change of 2 crew members. My lords, in the last occasion also, your lordships have permitted by the orders dated 9th February 2024. Lords, we want to change 2 crew members.
Lord, without interruption, the IA which we endorse no objection is to shift the vessel from the berth of the port to outer anchorage so that they can save the port charges. Now they want to sign off.
Lords, that's already permitted at para 8 of your lordships.
It is
previous order.
permitted, but as far as this case is concerned, I have to check with the clients, get an instruction, whether presence of these clients are required for trial. So there should be an undertaking and all. We'll file a formal objection tomorrow, and along with that, whether it can be heard on Friday or along with the main.
These, my lords, if your lordships were to see paragraph number 8 of the previous order, my lords.
Just one.
There are 8 of the orders of 9th February 2024. Lords, with regard to the signing off of the 4 crew members, the respondent shall permit to sign off 4 crew members and also employ 4 other personnel to continue the duties that were being done by the said 4 crew members. Respondent shall place on record in form of an affidavit the name of the 4 crew members who are being signed off and the 4 new crew personnel who have assigned with their duties. Now, from out of these 4, we are now replacing 2 more members. I have given their names and designation. And the passport numbers, all the other details are furnished. If their presence for any reason is required, your lordships may record that we will keep them present in the event their presence is required. That's our responsibility to keep them present because they will be our witnesses. There is no way that they will be calling them as their witnesses. It's for me to keep them present. The rank is also the same, my lords. The crew members whom we are replacing, the rank is also the same. If your lordships were to take my application, my lords, at internal page 3, it's a very innocuous
crew change. If your lordship is satisfied that let them give an undertaking, that as and when required by this court for trial, they will produce and let the crews also give an undertaking. That even they can
That can be done, my lord. That shouldn't be an issue. Because it's for me to examine the crew members in the event I require it. No, it's not for them.
So just 1 minute, just wait. I'll just barely mention your name. Just wait.
Lordships.
My lord, kind permission, my lord, serial number 26, my lord, first list.
Serial number 26.
My lord, kindly have it next week, my lord.
26.
I inform the other side also.
26. List 1.
List 1.
List 1, 26, my lord.
Relist the matter on date.
6th.
Yes,
Serial number 21, my lord.
yes.
My learned friend is also here. File the synopsis, the lordship should take it up in the first week of March. And file a synopsis also and proceed with it.
List 1.
List 1, 21.
At
The
re-
person's father.
at
Anand
request-
is also.
at request, list the matter on
11. Yes.
synopsis to be filed by both sides.
Serial number 29, my lord.
Yes,
And for the respondent number 8 in 29.1 and 2, my lord. Kindly have it on next week, my lord.
29. List 1.
you appear for,
R8, respondent number 8, my lord, in 29.1 and 2.
have you informed the petitioner?
Please, man,
At request,
29,
list the matter on
next week any date, man.
12th.
Serial number 38, my lord, list number 2.
list number.
List number 2, serial number 38. I am for the respondent. Petitioner is also present. Now the mediation is in process, my lord. There is a chance of settlement. I pray for 4 more weeks, my lord.
List after
4 weeks. my lord.
4 weeks. As it is submitted that parties are exploring possibility of settlement. Interim order earlier granted is extended till the next date.
Please, my lord.
Please.
Serial number 24 in first list. I am for the petitioner. I have also informed the respondents. May I request
I'm
for
for-
next week, my
I'm
lord.
for respondent number 2, my lords. I'm for respondent number 2, my lords.
I'm objection for active time. It is an appeal thousand. Signature to the order. Therefore, when the date is given, so that
Yes, relist,
it is there.
relist the matter on.
12th.
Please.
Yes.
Serial number 2, my lord. Serial number 9.
My lord, serial number 31,
Which list?
second list, my lord.
Yes,
My lord, it's already in BMC, Mediation Center, my lord. Kindly have it in 15th of next month, my lord.
Yes,
The other
yes.
side also present.
She has taken the time for the, to decide, 13 years taken. After that,
let us, after 3 weeks, we'll have it.
Please, my lord.
In case something happens, you move it to
Please, my lord.
list after 3 weeks.
Much
Serial number
obliged.
39. List number 2. Pay the fee of, will be listed after 4 weeks.
Your Lordship, serial number 39 and list to CEO Gharle undertakes to file wakalat, Your Lordships. A copy may be served upon us.
Undertakes.
List 2, serial number 19. Bharat ke?
19. Once, when you move, you should not take, when you move, you should not take an adjournment.
Sorry, my lord, there is some.
5-3.
And it's one detail file. First.
One.
Lordships.
Lord, I'm told that they have not yet filed the IE. I got an email copy.
They file.
I've given the file. Yeah, it's fine.
You have number? Okay, okay. File number ಆಗಿದೆ. Interlocutory application has been filed.
file ಮಾಡಿದ್ದಾರೆ. Number marks.
Seeking for direction to the new Mangalore port to allow the respondent vessel to sign off 2 crew members and sign on 2 crew members in place thereof on board the respondent vessel in the interest of full stop. it is submitted that there's a requirement to shuffle the crew as sought for. And this would be in consonance with the earlier order passed by this court on 9/2/2024. The application is filed on behalf of the respondent. It is submitted on behalf of the petitioner that the apprehension of the petitioner regarding the two crew members who are sought to be signed off to be present at the time of giving of evidence requires to be addressed. Taking note of the objection raised, application is allowed. The shuffling of who is sought for is allowed. As allowed, the respondent to file an affidavit within a period of 1 week.
Lordships.
To keep the two crew members permitted to be signed off at the time of evidence,
if need be.
if so called upon.
Lordships.
Needless to state that the two crew members who are also permitted to be signed off, also to file affidavit on same line.
Lordships.
Lord, maybe to the same crew already signed off. They should also give an undertaking on their behalf.
That's what I would.
No, earlier, when the other IA was allowed to ship the vessel, along with that.
The situation would arise only in the event if the matter goes into trial and their testimony is necessary. If I have to bring them in for the purpose of their testimony, this circumstance will arise. Presently, those things may not be necessary. That order has already been passed on 9th of February. That order may remain. So far as the present two crew members is concerned, their apprehension has been addressed. They have not challenged the orders dated 9th of February. They cannot seek for modification in the absence of any application.
No, I only endorsed no objection.
And
My
complaints
instructions
affidavit is also filed on 12th of February 2024.
No, let us see. We
And orders are passed on 13th of February.
summon them.
Yes, yes.
Lordships.
Look, if the normal prudent ship owner, they would have given a bank guarantee then and there itself and take the vessel. So they have no intention. Similarly, another vessel was arrested in Malaysia by me. There also no bank guarantee, nothing. Vessel is lying there for months. So suppose all the crews are one by one signed off, it will become a ghost vessel lying in Mangalore port. So minimum manning should be ensured by them. Otherwise, the value of this vessel also will go down.
It is.
Obligement.
Monday at 2:30 minutes.
This is the matter on Monday at 2:30.
Lordships.
Filed your synopsis.
Interim order.
No, have you all filed your, what is the stage now of the proceedings?
Lords, both the IS has to be heard, Lords. The application has been allowed ex parte by directing the arrest of the vessel, and we have filed an application raising the arrest. So both the applications has to be considered. Lords. Only a prima facie case will be considered, your Lordship's hands, whether to retain the vessel or not, what furnishing of the security, what undertaking.
Being an Admiralty suit, they have not yet filed a written statement. So only the prima facie case has been established or not. That is the only issue to be decided.
Both sides to file
Yes,
synopsis.
Lordships.
You file your synopsis.
We shall do that, Lords.
But interim order of arrest may be extended till date.
Interim order earlier granted is extended till the next day.
Lordships.
Obligement. Monday 2:30.
Yes.
Maybe.
Liberty matters, serial number 34, within NV, Nilapur Jewadi. Here is appearing in this.
May I please?
Yes.
I appear for the respondents' counsel.
VC check.
What is listed before the court is IA number 1. Made under Order 7, Rule 11, Code of Civil Procedure. Seeking rejection of the.
Can you hear, madam? Can you hear?
I've taken the mic out. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಅಂತಿದ್ದಾರೆ ಪ್ರಮೀಳಾ ಅವರೇ.
I am hearing, my lord, I am able to hear,
Yes, yes.
but I am not able to see, your lord.
We'll now,
Yes.
now cancel. We have been condensed. Yes. Yes.
Wait, please. Now, this is an application made under Order 7, Rule 11, seeking dismissal of the election petition. On the ground, it does not disclose a cause of action.
ಇಲ್ಲೇ ನೋಡು ಬಂದಾಗ ಹೇಳು.
Yes.
Now, in order to find out what is the cause of action that is called upon to be disclosed by an election petition, we have to look into the prayer. It is the prayer which determines whether a cause of action is disclosed or not. Kindly permit me to show from the election petition, which runs into about 80 pages, 62 pages. Kindly come to page number 55. These are the prayers made in the petition. The petitioner humbly prays that this honorable court be pleased to A. Declare that the declaration of results of the respondent, annexure B, for the assembly constituency of 219 Varna as void.
Just 1 minute, just 1.
Yes.
Yes.
This is prayer number 1. That my election is to be declared as void. Prayer number B may kindly be taken up. Declaring that the respondent has committed corrupt practice under sections 123(1), 123(2), 123(4), 123(6). In other words, all the provisions under the Representation of People Act dealing with corrupt practices.
4 are left. There are 8 corrupt practices. I have included only 4.
Yes, religion is left out. I agree.
4 are not.
Appeal on the ground of religion. I agree. I stand corrected. And more importantly, next to this thing, he was not qualified to be chosen. Kindly mark it. He was not qualified to be chosen to fill the seat of 219 Varna Assembly constituency, 101B. That deals with the qualification or disqualification of a returned candidate, 101B. But 101D4 is also added. I do not see any disqualification under 101D4. Be that as it may, there is a prayer. So in other words, if we analyze the prayer number 2, there are in all 6 prayers made. The first one is to declare that the returned candidate is guilty of bribery, committing the corrupt practice of bribery under section 123(1). These are independent grounds. I therefore would respectfully submit that they have to be considered independently to decide whether there is a corrupt practice of bribery. So allegation number 1 is under section 123(1) relates to bribery. Then 123(2) that relates to undue influence. Then 123/4, it relates to making false statement which is prejudicial to the candidate. According to the petitioner, it is the BJP candidate who is affected by that prejudicial statement. The false statements I have made have seriously prejudiced the election prospects of the BJP candidate is the allegation made against. And therefore, I am sought to be disqualified on that ground. 123/4. Then the next allegation is the prayer is under subsection 6 of section 123. Namely, I have spent more money towards my elections expenditure than what is permitted under law. Namely, section 77 read with 90. Of course, not in so many words they have said, but this is what they have sought. 123/6. Of the Representation of People Act. Then, that he was not qualified to be chosen to fill the seat of 219 Varna Assembly constituency. Now, question of qualification or disqualification would normally arise where it is a constituency reserved for either scheduled castes or scheduled tribes. Be that as it may, that allegation is made and a prayer is sought under 101B. Sorry, I should have read out too. May I start from 123?
Yes.
To bring in some clarity.
Yes.
123, corrupt practices. The following shall be deemed to be corrupt practices for the purpose of this act. 1. Bribery, that is to say, any gift, offer, or promise by a candidate or his agent, or by any other person, with the consent of a candidate or his election agent, of any gratification to any person whomsoever, kindly mark it. What is essential is a gratification to any person whomsoever with the object directly or indirectly of inducing a person to stand or not to stand as or withdraw or not to withdraw from being a candidate at an election, or B. An elector to vote or refrain from voting at an election, or as a reward to 1. A person for having so stood or not stood, or for having withdrawn or not having withdrawn his candidate. 2. An elector for having voted or refrained from voting. Sir, kindly mark it. The essential requirement is I should offer a gratification in order to do all these acts. B. The receipt of or agreement to receive any gratification, whether as a motive or a reward, by a person for standing or not standing as, or for withdrawing or not withdrawing from being a candidate, or by any person whomsoever, for himself or any other person, for voting or refrain from voting, or inducing or attempting to induce any elector to vote or refrain from voting, or any candidate to withdraw or not to withdraw his candidature. Explanation. For the purpose of this class, the term gratification is not restricted to pecuniary gratification or gratifications estimable in money, and it includes all forms of entertainment and all forms of employment for reward, but it does not include payment of any expenses bona fide incurred at or for the purpose of any election and duly entered in the account of election expenses referred to in section 78. So this is the requirement of bribery and 123(1). Then the second requirement is undue influence 123(2). And undue influence, that is to say, any direct or indirect interference or attempt to interfere on the part of a candidate or his agent or any other person with the consent of the candidate or his election agent, with the free exercise of any electoral right, provided that without prejudice to the generality of the provisions of this clause, any such person as is referred to therein, who threatens any candidate or any elector, or any person in whom a candidate or an elector is interested, with injury of any kind, including a social ostracism, and excommunication or expulsion from any caste or community, or includes or induces or attempts to induce a candidate or an elector to believe that he or any person in whom he is interested will become or will be rendered an object of divine displeasure or spiritual censure, shall be deemed to interfere with the free exercise of the electoral right of such candidate or elector within the meaning of this clause. B, a declaration of public policy or a promise of public action or the mere exercise of, kindly mark this is crucial, a declaration of public policy or a promise of public action or the mere exercise of a legal right without intent to interfere with an electoral right shall not be deemed to be interference within the meaning of this clause. If I may say so with respect, the entire case of the election petitioner, it comes within this class B, proviso, class B. 3.
No, the second phrase is or a promise of public action, is it?
Yes, action. The thrust of the election petition is that we have issued an election manifesto. And in the election manifesto, we have held out 5 guarantees. And those 5 guarantees amount to bribery, undue influence, also a false statement. I'll go to the details later, but these are the allegations which has seriously prejudiced. So 3 is not, I think this is the only provision left out. 3 is not.
5 is also not left out. 5 I will not have lead. Booth capturing I will not have lead.
Agreed. Hiring the government servant, agreed. Appealing on the basis of religion, because that they have done. I have not indulged it. Very fairly they have left out. Then 4. I stand corrected, Madam. The publication by a candidate or his agent or any other person with the consent of a candidate or his election agent of any statement of fact which is false. Pausing for a minute. It is their case. The entire manifesto is a false statement. All the 5 guarantees are false statements. Resume. With the consent of a candidate or his election agent of any statement of fact which is false and which he either believes to be false or does not believe to be true in relation to the personal character or conduct of any candidate or in relation to the candidature or withdrawal of any candidature, being a statement reasonably calculated to prejudice the prospects of the candidate selection. I request the court to kindly mark in relation to the personal character of the BJP candidate. That is what is required to be alleged. Let us see whether they have alleged it. Then kindly come to 6, which is the next corrupt practice alleged against me. (123)(6). Incurring or authorizing of expenditure in contravention of section 77. So these are the 4 prayers, 4 indictments of corrupt practice leveled against me. Then kindly come to section 100, which is invoked in the same prayer. I don't know why they are clubbed and what is common between 123 and 100, be that as it may. 100 is also invoked. 101B may kindly be perused. Here it's section 101. Grounds for declaring election to be void. Subject to the provisions of subsection 2. The High Court is of opinion, A, that on the date of his election, that is not alleged, I'll skip it. B, that any corrupt practice has been committed by a returned candidate or his election agent, or by any other person with the consent of a returned candidate or his election agent. So that is alleged. Then, sorry, I should have read A also because qualification is also raised. 1A. That on the date of his election, a returned candidate was not qualified and was disqualified to be chosen to fill the seat under the Constitution or this Act or the Government of Union, etc., etc. Now, the allegation is I was not qualified to be chosen to fill the seat of Varuna constituency. That is the allegation. So 1A, 101A is invoked. Then 101D may kindly be perused. However, the prayer is about B, though qualification is mentioned, 1A is not referred. Only the petitioner can explain what is the implication. D may kindly be that the result of the election, in so far as it concerns a returned candidate, has been materially affected by the improper acceptance of a nomination, by any corrupt practice committed in the interests of the returned candidate by an agent other than his election agent, or by the improper reception, refusal, or rejection of any vote, or the reception of any vote which is void, or they have invoked 4. So this is important. 4. By any non-compliance with the provisions of the Constitution or of this Act or of any rules or orders made under this Act, the High Court shall declare the election of the returned candidate to be void. So this is the ground that is invoked, D4. What is the non-compliance? Entire Representation of People Act is violated. What is the constitutional provision? Entire Constitution is violated. I'll read out. Or of this Act, that is the Representation of People Act. The rules are also invoked. All the rules are invoked. And orders issued by the Election Commission are also invoked. So lock, stock and barrel, this election is in violation. The Constitution, the Representation of People Act, the conduct of election rules, and the code of conduct issued by the Election Commission. That is the allegation. So these are the prayers made at class B. Then class C may kindly be. So in other words, class B has 6 components. Besides the first prayer. So that makes it 7 prayers. Now come to C. To declare that the result of the election of the respondent has been materially affected by the improper reception and counting of votes. Kindly mark it. This is a very interesting prayer. In the entire writ petition, there is not a whisper about counting of votes. But there is a prayer. It has been materially affected by the improper reception. There is no allegation anywhere in the petition that any vote is improperly accepted or received. Much less is there an allegation that counting of court votes in favor of the respondent as void under section 101 capital A D4. Now, may I request the court to kindly come back to section 100. In fact, my learned colleague has been searching from morning. Where is this provision? Section 101 capital A. She did not find it. I thought I'll report it to the court so that the petitioner will find it. It doesn't. There is no capital 1A. So this is an imaginary grievance and an imaginary relief sought by the petitioner. Purely imaginary. Then this will be the 9th prayer. To make an order regarding the corrupt practice committed by persons other than the respondent in the election held for 219 Varuna Assembly constituency and name them and take action as contemplated under section 99 of the Representation of People Act 1951. They have named D.K. Shivkumar. Other persons, court will have to find out and name them. This is like an FIR registered in a case of hit and run, where the assailant is not known. So the court will have to find out. Then the next one is pass such other orders deemed necessary under section 125 capital A. So these are the 11 prayers that are made. So I'll now take this honorable court to show whether there is any cause of action disclosed in respect of any one of these 11 prayers. In order to understand that, we'll have to find out what is the cause of action that is required to be disclosed in an election petition. That the court will get it at section 83. May I request the court to kindly.
Insofar as prayer D is concerned.
D.
With respect to the scope of section 99.
Yes.
We have dealt with in the petition relating to Tumkur constituency on the previous occasion.
Please.
Some observations.
I'll look into it. I'll look into it. But the question is whether there is any cause of action disclosed in this. I'll definitely look into the observations of this court in the Tumkur constituency. Now, kindly come to section 83. Sir, if I may say so with respect, this is the all-important section which mandates the
type of cause of action that needs to be disclosed. If I may say so with respect, this is very much similar to the law of pleadings we are familiar with under the Code of Civil Procedure, particularly Order 6. Contents of a petition. An election petition shall contain a concise statement of material facts, kindly mark it. Material facts on which the petitioner relies. Identical to Order 6, Rule 1. B. Shall set forth full particulars of any corrupt practice that the petitioner alleges, including as full a statement as possible of the names of the parties alleged. Kindly mark it. Names of the parties alleged to have committed such corrupt practice. Bribery. Did Sidramaya distribute the money? Did his election agent distribute the money? And more importantly, the date and place of commission of each of such practice. That very, very crucial statements that are required to be made. If X bribes a voter Y, the names will have to be given. Not only the names, the place where the money was given. Not only the place where the money was given, but the time and the date when it was given. They have to be disclosed. These are what are known as the particulars that are required to be made. Material facts are what are known as. The law is very well settled, if I may say so with respect. Series of judgments have dealt with this, because the dividing line between particulars and facts is a very, very thin line. So one test which is accepted is cause of action in an election petition. The material facts will have to be disclosed as mandated under Section 83(1), which has been held to be 1A, which has been held to be mandatory. Now, what are material facts? Material facts are those which constitute the entire case of the election petitioner, which, if they are not traversed by a contesting respondent, they should result in grant of relief. In other words, all the 11 reliefs that are paid for by the petitioner should be granted automatically if I don't appear and contest. If I may say so with respect, the cause of action is what makes the election petition stand on its own, like a skeleton stands in respect of a human being. Particulars are the flesh and blood of those statements to fill in the gaps, to provide the necessary details. But what is very important is 4 corrupt practices are alleged. All the 4 corrupt practices should be disclosed in their entirety. There should not be omission of a single material fact. That by itself should entitle the election petitioner to earn an order from this honorable court invalidating the election on that count. Now, those are material facts which have been. So this is very well established. Next clause is also important. I'll show the court how lock, stock and barrel this petition is liable to be thrown to the dustbin. Clause C. Shall be signed by the petitioner and verified in the manner laid down in the Code of Civil Procedure for verification of pleadings. This has also been held to be a mandatory requirement. There is a very important proviso. Kindly permit me to read the proviso as well. Provided that where the petitioner alleges any corrupt practice, the petition shall also be accompanied by an affidavit in the prescribed forum in support of the allegation of such corrupt practice and the particulars thereof. So not only a verification, but the mandatory requirement is forum 25. Affidavit also to be sworn in and filed. That is section 83(1). 83(2). We have not yet filed an application on this. We have kept it reserved. 83(2). Any schedule or annexure to the petition shall also be signed by the petitioner, verified in the same manner. That we are not pressing into service now. Sir, keeping that in mind, kindly permit me to read what is the verification at page 56.
This aspect also.
Sir.
We have dealt with in the IA filed in the previous proceeding, which was also taken up in appeal and challenge was unsuccessful. Some observation regarding verifying affidavit also can be.
I'll look at this. I, so and so, petitioner hearing, do hereby verify that the statements made in paragraphs 1 to 14A to 14E, 14H to 14T, 14Z, 14AA to 14II, 17 to 18, Z, 21 to 27 are true to my knowledge. Kindly mark it. Are true to my knowledge. The statements made in paragraphs 14F, 14G, 14U to 14Q, 18Q, 18(6), 18R, sorry, 18R and 20 are based on, are true to my information. I'm reading it as it is. Are based on what? Are true to in the information. The statements made in paras 15, 16 are based on the belief. Whose belief? Are based on the belief. The source of this is, I request the court to, for the first time in 50 years practice, I am coming across a verification. The source of information of the statements made in manifesto, newspaper, pamphlets, electronic media, social media, in paragraphs 1 to 76 are based on legal advice and are true to my belief. Sir, just turn one leaf back. Paragraphs 1 to 76. I have been searching for the paragraphs from 28 onwards up to 76. My instructing counsel was not been helpful. She did not locate any paragraphs after 27. But what are verified are 1 to 76, a fantastic verification. All in the air. Pleadings are in the air. Verification is still higher in the air. Equally interesting, kindly come to the affidavit next page.
No, it says para 1 to 14A.
Last line, last but one line rather. The source of information for the statements made in the manifesto, newspaper,
Yes, yes,
pamphlets,
yes.
electronic media. No, some are based on his own knowledge. Some are based on some belief, whose belief he doesn't say. And the rest are based on legal advice. And that he believes, that is based on my belief. That para 1 to 76, I am unable to find. Where are those paragraphs? They are anyway not in the pleadings. I have not come across a more cavalier verification that has been done. It is an election petition. It's an election petition against a chief minister. Look at the statement that is made in the verification, that which is supposed to be the most critical part of a pleading. Page 60 is the mandatory statutory affidavit that is filed. Verifying affidavit is also filed. Kindly turn to page 58. When lies are told, it is told on oath also. That is a verification telling the bundle of lies. Now kindly come to the affidavit, verifying affidavit. I submit that the statements made in paras now 1 to 14A, 14E, 14H to 14T, 14Z, 48, etc., are true to my knowledge. The statements made in paragraphs 14F, etc., are based on or true to the information. Which information? The statements made in paragraphs 15, 16 are based on the belief. Whose belief? The source of information for the statements made in the manifesto, newspapers, pamphlets, electronic media, social media, in paragraphs 1 to 76 are based on legal advice and true to my belief. So, verbatim the same. Now kindly come to the next page. Para 1. I am the petitioner in the above case. I am conversant with the facts and circumstances of the case. I am filing this affidavit regarding the corrupt practices. I have filed this affidavit under section 83(1) proviso, as I have alleged corrupt practice against the respondent in the election petition. I am filing this affidavit in support of the allegations made by me regarding the corrupt practices. I submit that the averments made by me in the election petition pertaining to the corrupt practices under section 123(1)(A), B2, 123(1)(B), B, 123(2), 123(4), 123(6), of the Representation of People Act are true to the best of my knowledge. Sir, repetition of even the exact language of the section, like a mantra, will not fill in the void. There are authorities, I'll cite it. Here, not even a word bribery is mentioned. Not even the words undue influence is mentioned. Not even the allegation that there is a false statement is mentioned. Tell in the court, you look at the section 123, 1B, 123, 1A, 123, 2, 120. Whether this would be the affidavit which would satisfy, I'll demonstrate that this by itself is enough to throw out this petition. Para 4. Regarding the averments made by me pertaining to the material facts, material particulars. Statute doesn't require material particulars. It requires material facts, that is the cause of action. It requires full particulars, that is 83(1)(b). Now, but anyway, it says material particulars for corrupt practices under section 123(1) regarding bribery pertaining to guarantees and promises made to the voters are true to my information. The material particulars and the material facts as stated by me regarding the said corrupt practice are in paragraphs 14 and 25 to 27. Regarding the averments made by me pertaining to material facts and material particulars for corrupt practice or undue influence under section 123(2), I state that they are in paragraph numbers 18, 20, 25 to 27. I state that they are true. I further state the same are within my knowledge and information, and I believe them to be true. Regarding the averments made by me pertaining to material facts and material particulars for corrupt practice of false publication under section 123(4), I state that they are in paragraphs 14 to 20, 21 to 27, and I state that they are true. I further state that the same are within my knowledge and information, and I believe them to be true. Regarding the averments made by me pertaining to section 1, pertaining to material facts and material particulars for corrupt practice under section 123(6), incurring or authorizing expenditure in contravention of section 77 of the Representation of People Act and rules, I state that they are in paragraphs 74 and 75. I state that they are true. I further state that the same are within my knowledge and information, and I believe them to be true. The documents referred to by me in all paragraphs pertaining to corrupt practices are true copies. Source of information. Sir, kindly mark this. Source of information. This honorable court is now called upon. This is a challenge to the court to test this source, veracity of the source of information. What is the source of information? For averments in the petition for the corrupt practices, election manifesto, guarantee cards, print media, electronic media, books published on economy and finance, web sources, and analysis by the economist Sri Vishweshwar Bhatt. I have asked my learned friend to find out where is Vishweshwar Bhatt's work on economy. She is unable to locate any work. The petitioner may throw some light so that the great economist may also be introduced to this court. So this is the verification, sir. This is the verifying affidavit mandated under section 83, which has been filed. So I'll come back to the facts of the case as to how there is total bankruptcy in the election petition in its failure to disclose any material fact. And the law is so well settled. Not only all material facts are required to be stated. Even one single material fact has not been disclosed, that will be fatal to the maintainability of the petition. There are hundreds of judgments. I'll not trouble the court with all of them. I'll just trouble the court with the latest judgment.
Kanimoli.
Hello, hello. The latest judgment in Kanimoli's case has very comprehensively reviewed the entire case law. Kindly permit me to read it in extensive. This is reported in 2023 SCC online, SC 573, Kannimoli Karunanidhi versus A. Shantakumar and others. So these are allegations of corrupt practice made against the appellant before the Supreme Court, and the under Order Rule 11, matter was brought up to the Honorable Supreme Court. Kindly come to Para 18, legal position. (18, 19, 20) generally deal with the scheme of the elections. They'll not trouble the court. Para 22 is sufficient to read. Para 26, 22, bottom of page number. Para 22. Madam, copy ಕೊಟ್ಟಿದ್ದೇನೆ ನಿಮ್ಮ colleague.
I know the Kanimoli's case, don't worry.
The respondent election petitioner in this
I'll collect
case.
from him, don't worry.
The respondent election petitioner in this case has challenged the election of the appellant returned candidate under section 101D4 on the ground of non-compliance of the said rule, Rule 4A, and the Form 26. However, the appellant had filed an application seeking dismissal of the election petition in limine for non-compliance of the provisions of section 83(1)A, read with Order 7, Rule 11 of the CPC. The law so far developed and settled by this court with regard to the non-compliance of the requirements of section 83(1)A of the Election Petition Act, it should be Representation Act, namely, an election petition must contain a concise statement of material facts on which the petitioner relies, is that such non-compliance of section 83(1)A, read with Order 7, Rule 11 of the Code of Civil Procedure, may entail dismissal of the election petition right at the threshold. Material facts are facts. Kindly mark it. Material facts are facts, which, if established, would give the petitioner the relief asked for. The text required to be answered is whether the court could have given a direct verdict in favor of the election petitioner in case the returned candidate had not appeared to oppose the election petition on the basis of the facts pleaded in the petition. There must be such facts as would afford a basis for the allegations made in the petition and would constitute a cause of action as understood in the Code of Civil Procedure. Material facts would include positive statement of facts as also positive statement of a negative fact. a three-judge bench in Harishankar Jain versus Sonia Gandhi had an occasion to deal with section 83(1)(A). And the court dismissed the election petition, holding that the bold and vague averments made in the election petitions do not satisfy the requirements of pleading material facts within the meaning of section 83(1)(A) of the Representative People Act, read with the requirement of Part 7, Rule 11. It was observed in paras 23 and 24 as under quote. Section 83(1)(A) of the Representation of People Act mandates that an election petition shall contain a concise statement of the material facts on which the petitioner relies. By a series of decisions of this court, it is well settled that material facts required to be stated are those facts which can be considered as materials supporting the allegations made. In other words, they must be such facts as would afford a basis for the allegations made in the petition and would constitute cause of action as understood in the Code of Civil Procedure. The expression cause of action has been comprehensively defined to mean every fact which it would be necessary for the plaintiff to prove, if traversed, in order to support his right to the judgment of the court. Omission of a single material fact, kindly mark it. Omission of a single material fact leads to an incomplete cause of action, and the statement of claim becomes bad. The function of the party is to present as full a picture of the cause of action with such further information in detail as to make the opposite party understand the case he will have to meet. Merely quoting the words of the section, like chanting of a mantra, as it has been done in our case. Merely quoting the words of the section, like chanting of a mantra, does not amount to a stating of material facts. Material facts would include positive statement of facts as also positive averments of a negative fact, if necessary. In B.S. Achyutananda versus P.J. Francis, this court has held on a conspicuous series of decisions of this court that material facts are such preliminary facts which must be proved at the trial by a party to establish existence of a cause of action. Failure to plead material facts is fatal, kindly mark it. Failure to plead material facts is fatal to the election petition, and no amendment of the pleadings is permissible to introduce such material facts after the time limit prescribed for filing the election petition. It is the duty of the court, kindly mark it, sir, the very emphatic statement. I will also place authorities to show this honorable court is empowered suo motu to dismiss the election petition, even before issuing the summons, or even after issuing the summons. That's one of the duties cast on the court, election judge. So it is the duty of the court to examine the petition, irrespective of any written statement or denial or reject the petition if it does not disclose a cause of action. To enable a court to reject a plaint on the ground that it does not disclose a cause of action, it should look at the plaint and nothing else. Courts have always frowned upon vague pleadings. Kindly mark it. This can be a textbook illustration, sir. This petition can be a textbook illustration of what a vague pleading can be. So I repeat, courts have always frowned upon vague pleadings which leave a wide scope to adduce any evidence. No amount of evidence can cure basic defect in the pleadings, unquote. In case of Mahadev Rao Sukaji Shivshankar versus Ramanathan Bapu, a three-judge bench of this court again had an occasion to deal with the issues as to what would constitute material facts and what would be the consequences of not stating the material facts in the election petition, as contemplated under section 83(A). Quote, now it is no doubt true that all material facts have to be set out in an election petition. If material facts are not stated in a plaint or a petition, the same is liable to be dismissed. On that ground alone, as the case would be covered by Clause A of Rule 11 of Order 7 of the Code. The question, however, is as to whether the petitioner had set out material facts in the election petition. The expression material facts has neither been defined in the Act nor in the Code. It may be stated that the material facts are those facts upon which a party relies for his claim of or defense. In other words, material facts are facts upon which the plaintiff's cause of action or the defendant's defense depends. What particulars could be said to be material facts would depend upon the facts of each case, and no rule of universal application can be laid down. It is, however, absolutely essential that all basic and primary facts which must be proved at the trial by the party to establish existence of a cause of action or defense are material facts and must be stated in the pleading of the party. But it is equally well settled that there is a distinction between material facts and particulars. Material facts are primary or basic facts, which must be pleaded by the petitioner in support of the case set up by him, either to prove his cause of action or defense. Particularly on the other hand, particulars on the other hand, are details in support of the material facts pleaded by the party. They amplify, refine, embellish material facts by giving finishing touch to the basic contours of a picture already drawn as to make it full, more clear, and more informative. Particulars ensure conduct of fair trial and would not take the opposite party by surprise. Anil Vasudev Salgaonkar versus Naresh Kushali Shigaonkar. This court has discussed number of earlier decisions on the issue as to when the election petition could be dismissed summarily if it does not furnish the cause of action in exercise of the powers under the Code of Civil Procedure, read with Section 83 of the Act. Quote, the position is well settled that an election petition can be summarily dismissed if it does not furnish the cause of action in exercise of the power under the Code of Civil Procedure. Appropriate orders in exercise of powers under the Code can be passed if the mandatory requirements enjoined by Section 83 of the Act to incorporate the material facts in the election petition are not complied with. This court in Samant Balkrishna case has expressed itself in no uncertain terms that the omission of a single material fact would lead to an incomplete cause of action, and that an election petition without the material facts relating to a corrupt practice is not an election petition at all. I repeat, sir. This court in Samant Balkrishna's case, that is Judge Fernandez court, kindly recollect, Judge Fernandez case, where he was elected to the parliament first time, has expressed itself in no uncertain terms that the omission of a single material fact would lead to an incomplete cause of action, and that an election petition without the material facts relating to a corrupt practice is not an election petition at all. In Uday Singh versus Madhavrao Scindia, the law has been enunciated that all primary facts which must be proved by a party to establish a cause of action or his defense are material facts. In the context of a charge of corrupt practice, it would mean that the basic facts which constitute the ingredients, sir, kindly mark it, this is very essential, ingredients. That's why I read every provision has its own ingredients. Bribery has its own ingredients. Undue influence has its own. They will have to be specifically pleaded. The basic facts which constitute the ingredients of the particular corrupt practice alleged by the petitioner must be specified in order to succeed on the charge. Whether in an election petition, a particular fact is material or not, and as such, required to be pleaded is dependent on the nature of the charge leveled and the circumstances of the case. All the facts which are essential to clothe the petition with complete cause of action must be pleaded, and failure to plead even a single material fact would amount to disobedience of the mandate of section 83(1)(A). Election petition therefore can be and must be dismissed if it suffers from any such vice. The first ground of challenge must therefore fail. In Narayan Swamy versus Tiruvakkunarasu, this court reiterated the legal position that an election petition is liable to be dismissed if it lacks in material facts. In Shiramegoda versus T.M. Chandrasekhar, this court again considered the importance of the pleadings falling within the scope of section 123 of the Act and observed thus, quote, this court has repeatedly stressed the importance of pleadings in an election petition and point out the difference between the material facts and the material particulars. While the failure to plead material facts is fatal to the election petition, and no amendment of the pleading could be allowed to introduce such material facts after the time limit prescribed for filing the election petition, the absence of material particulars can be cured at a later stage by an appropriate amendment. In Uday Singh's case, this court observed thus, quote, like the Code of Civil Procedure, this section also envisages a distinction between material facts and material particulars. Clause A of subsection 1 of section corresponds to Order 6 Rule 2, while Clause B is analogous to Order 6 Rule 4 and 6 of the Code. The distinction between material facts and material particulars is important because different consequences may flow from a deficiency of such facts or particulars in the pleading. Failure to plead even a single material fact, I repeat, failure to plead even a single material fact to an incomplete cause of action and incomplete allegations of such a charge are liable to be struck off under Order 6 Rule 16 Code of Civil Procedure. If the petition is based solely on those allegations which suffer from lack of material facts, the petition is liable to be summarily rejected for want of a cause of action. In the case of a petition suffering from a deficiency of material particulars, the court has a discretion to allow the petitioner to supply the required particulars even after the expiry of limitation, unquote. In H.D. Revanna, the appeal was filed by the candidate who had succeeded in the election and whose application for dismissal of the election petition in limine was rejected by the High Court. This court noticed that it has been laid down by this court that non-compliance with the provisions of section 83 may lead to dismissal of the petition if the matter falls within the scope of Order 6 Rule 16 and Order 7 Rule 11 of the Code of Civil Procedure. In Harmohinder Singh Pradhan versus Ranjit Singh Talwandi, this court observed, quote, necessary averment of facts constituting an appeal on the ground of religion to vote or refrain from voting would be material fact within the meaning of Clause A of subsection 1 of section 83 of the Act. If such material facts are missing, they cannot be supplied later on after the expiry of period of limitation for filing the election petition, and the plea being deficient can be directed to be struck down under Order 6 Rule 16 of the Civil Procedure. And if such plea be sole ground of filing an election petition, the petition itself can be rejected as not disclosing a cause of action under Clause A of Rule 11 and Order 7 of the Court. In Harkirat Singh versus Amrinder Singh, This court again reiterated distinction between the material facts and material particulars and observed thus, quote, a distinction between material facts and particulars, however, must not be overlooked. Material facts are primary or basic facts, which must be pleaded by the plaintiff, by the defendant in support of the case, set up by him, either to prove his cause of action or defense. Particulars, on the other hand, are details in support of material facts pleaded by the party. They amplify, refine, and embellish material facts by giving distinctive touch to the basic contours of a picture already drawn, so as to make it full, more clear, more informative. Particulars thus ensure conduct of fair trial and would not take the opposite party by surprise. All material facts must be pleaded by the party in support of the case set up by him. Since the subject and purpose is to enable the opposite party to know the case he has to meet with, in the absence of a pleading, a party cannot be allowed to lead evidence. Failure to state even a single material fact, kindly mark it, failure to state even a single material fact, hence will entail dismissal of the suit or the petition. Particulars, on the other hand, are the details of the case, which is in the nature of evidence a party would be leading at the time of trial. In Sudarsha Avasti versus Shivpal Singh, this court observed the election petition is a serious matter. Sir, this is very important. Election petition is a serious matter. It cannot be treated lightly and in a fanciful manner, nor is it given to a person who uses this as a handle for vexatious purpose. Sir, an all-important observation. I will repeatedly impress upon the court the need to deal with it in that perspective, with all seriousness, because the cavalier manner in which allegations are made, reckless and wild propositions are put forward in this petition, deserves very strong condemnation. It is settled legal position that all material facts must be pleaded by the party in support of the case set up by him within the period of limitation. Since the object and purpose is to enable the opposite party to know the case he has to meet with, in the absence of a pleading, a party cannot be allowed to lead evidence. Failure to state even a single material fact will entail dismissal of the election petition. The election petition must contain a concise statement of the material facts on which the petition. There is no definition of material facts. I'll not trouble the court with the next paragraph. It has already been read. Kindly come to.
We can continue.
Sorry.
We'll have it. Tomorrow is okay. We can continue tomorrow after 3:30.
Tomorrow in the forenoon session, I'm before lunch.
Saturday, could your lordship have work? Well, tomorrow.
Otherwise we'll have it on Tuesday after
Yes.
lunch. Tuesday after lunch.
That will be fifth, my lord.
I just before coming to the court noticed that there is already a direction by this honorable court that we should file our written submissions on this application as well. That is being prepared. Since the facts and grounds have been jumbled up and the prayers as court has already seen, with great difficulty, my learned colleague is trying to decipher what is to be placed in which jacket. So if some more time is given, we'll file this written submissions as. Otherwise, I can go on.
No objection, my lord. Let him have. Let him give the copy to me.
I think it will be reciprocated.
No,
But they're.
no, no quarrel between us.
They're seeking some more time to file the written submission.
No objection on the argument.
Then it could be on the 13th, my lord. 13th of, because the 12th other cases, 11th and 12th other cases are fixed. 13th of this month,
Yes.
March, my lord.
Agbo.
13th at 2:30.
Ah, good. 13th at 2:30.
Yes. The arguments of learned senior.
I,
counsel appearing.
I'm sure that Ravi will give me the copy of the submission.
Sure, sure.
Yes.
Remains incorrect.
I've always been fair to you.
Is the
I
matter-
know, I know.
is the matter for further argument. Huh?
1978, she had filed a case against Devarajaras. We were in a similar situation. 76 petitions she had filed.
On IA 230, 30. IA number. Yes.
Please. Oblige.
Yes. Any other decisions, Ravi? Any other authorities, Ravi?
No, one decision. There's only one decision.
Any
Any other authority? I just wanted to know.
I'll give you a written submission along with the authorities. I'll give you a written submission along with the authorities. Oh, sorry. I'll give you a written submission along with the authorities.
Thank you, thank you,
Okay.
thank you.
Voting rights, my lord. Election is scheduled tomorrow.
Now, what we are finding in one matter, that by interim order, permission was granted. But on appearance, they're not in a position to demonstrate that they've attended meetings and have had business. So you must file one affidavit. We'll grant the interim order. However, within 3 days, you'll have to file an affidavit along with material to show at least 13D has been, you are now you are qualified under 13D.
Please, ma'am.
Because he filed for some 135 members and he wants 3 weeks time to establish that he is not disqualified.
We'll do it, ma'am.
Yes, same order. Petitioner. When is the date of election?
Tomorrow, my lord.
Petitioner to file affidavit. That same order. To demonstrate
That he has complied with section 20A5, my lord.
that he has complied with
Section 20A5.
that there has been that the petitioner has complied with section 20
A5.
A Roman 4 and A5.
Lord Roman 4 that the attending minimum general body
Correct.
meeting.
Let them then state because of COVID or whatever.
Oblige.
And in the event and for the purpose of compliance with A Roman 4, reference can be made of meetings not held during the COVID period.
Even,
COVID-19 pandemic period. Such affidavit to be filed within 3 days.
On or before Monday, my lord.
On or before Monday date. 4th. list this matter on,
Election is tomorrow, my lord. It may be Monday only.
okay, on by the next date, that is on 4th.
I seek for hand delivery, my lord.
It will be uploaded immediately. Yes. AG accepts notice for respondents. 135. Council
Kiran Kumar for 2.
For 2. Emergent notice to the 4th respondent.
4.
Petitioners permitted to take out notice by way of hand summons as well. Societies are least bothered in anything.
Sometimes they are, the society.
They are the
sponsor.
answering respondent actually. Yes.
Okay, respondent, please. While taking transfer of MC, which is filed by respondent, my lord, pending in 4th Additional Family Court, Bangalore, to Bhadravati. my lord. Wife seeking a transfer petition where family respondent has filed a divorce petition in Bangalore, 4th Additional Family Court, my lord. As the marriage is solemnized on 18/8/2021, my lord.
You are seeking transfer to,
Bangalore to Bhadravati, my lord.
what is the distance?
216 kilometers.
216.
16.
216. Any children?
No, my lord.
You're working?
Working in Infosys, my lord, project manager, my lord.
In Bangalore, please.
Bangalore, that too, only 5 or 6 days, my lord, in a month.
You're working in Bangalore?
Yes.
She's working in Bangalore and staying in Bangalore.
No, my lord, no, my lord. She is not staying in Bangalore. She is coming from Bhadravati to Bangalore, my lord.
Every day?
No, whenever the project is there, she will come and after the finishes of the work, she will went back to the Bhadravati, my lord.
Your Lordship, one submission. Infosys has a direction that every employee shall work for 3 days in a week, 2 in Bangalore, please. That is their direction. But Your Lordship, I may.
Any direction, please.
I come, sir. Your Lordship, one submission.
No, 1 minute.
Yeah, please.
We will not enter into detailed argument. It's only a CP. You file an affidavit.
Yes,
regarding the nature of work.
Yes, my lord.
And
Lord,
nature of work.
for that
Bangalore.
instance, I filed a rejoinder for their objections, my lord.
They've accepted, please, my lord, that she comes to Bangalore every week.
They have filed objections that they stated in the paragraph, in the objections, that 11th para, they state that there are following address of the maternal aunt of the petitioner, Rekha and Kavita. The current address is so and so, so and so. The Bangalore address is mentioned, but they have not produced any documents in favor of that she is living in the Bangalore itself, my lord.
Your Lordship, this matter.
There is a maternal aunt's house in the Bangalore,
Which they've accepted, please.
Just 1 minute.
No, one.
Just 1
please.
minute. CPs, I'm not going to enter into any detailed trial.
Yes,
Yes,
my lord.
Regarding your coming and working at Bangalore.
Yes, my lord.
Where have you stated?
My lord.
Your Lordship, in the petition, please.
The rejoinder also.
This petition came into being because they say that she's working in Bhadravati and staying in Bhadravati.
No, my lord.
Your Lordship may kindly go to page number 6 of their petition, please.
I'll come to that. If required, I'll ask them to file affidavit.
I have
My lord.
filed.
I'll file, my lord.
I'll come to you. Just
Yes,
File, my lord.
Just wait.
Yes, please.
I'll file, my lord.
Where have you stated regarding the work?
My lord.
Work in your rejoinder.
Rejoinder, my lord.
Page para 7, please.
Lord, in the 7th para, my lord, they have stated that in their objection, para number 10 and 11, they are mentioned that petitioner has misled the High Court by stating that she is working at Bhadravati, but that is stated that petitioner is only earning in the family where the father of the petitioner was deceased at an early age, leaving behind mother and sister of the petitioner, my lord. My lord, petitioner father has died in the early age, my lord.
No, that will see. Now we are only on this. You file an affidavit.
Yes, my lord. I'll file my
The
affidavit.
petitioner is directed to file an affidavit detailing
Yes, my lord.
work at the Bangalore, work at Bangalore.
Your Lordship, he has admitted here, please.
The
My lordship,
details-
one
admits here.
submission, my lord, one
He
submission.
admits here that she's coming to Bangalore every week.
No, my lord,
No, just wait. Why are you arguing? Let me dictate at least.
my lord, one submission.
No, after I dictate you this, the affidavit to detail to be accompanied with an extract of days attended in the past 2 months issued by the Human Resource Development Department. Full stop. Affidavit to also state nature of work and
Designation, please.
designation.
Yes.
Such affidavit to be full stop. The requirement for filing of such affidavit is in the context of petition being filed where the petitioner seeks for transfer of proceedings to Shimoga,
Bhadravati, please.
Bhadravati.
to Bhadravati, though the petitioner admittedly is working at Bangalore. For filing of affidavit as directed, list the matter on when do you want?
My lord, one submission, my lord.
Mm.
In their objection, they state in the R3, my lord, there is a document which said in the page number 8, the R3, which states that Sahana Shivakumar Shiva Prasada Alayam, number 2, Maruti Seva Nagar, Bangalore 25, my lord. It is a welcome letter issued by the Infosys company.
Lordship, it's
Where is a respondent address, it is
it's
stated.
appointment letter.
There is no address mentioned in the.
Let me file the affidavit, please.
No, no. Now,
She is staying in a Bangalore, my
no,
lord.
you're working in Bangalore. is
Yes,
it?
my lord.
So you file the affidavit?
Yes, my lord.
please?
I'll file. I'll file.
When do you want it?
4 weeks, my lord.
No, not.
No,
My lord,
seventh, please, my lord.
There is, we have to take
Your
it
Lordship,
from the
there's one
Infosys.
more submission. This
No,
matter,
please,
no, no,
please.
no, sir.
CPs don't require so much time.
No, this matter is
no,
posted for arguments, final arguments, please.
No,
My
that's
lord, there is no final arguments on merits, my lord.
10 days wanted.
In
No,
default,
what-
it is meant for final arguments.
On 11th.
11th, it will be very.
11th, I oblige, please, my lord. 11th it is.
15th, my lord. Because we need to send a requisition for so-and-so application, my lord.
So online, please, my lord, you can take a printout.
Can't, my lord.
On 15th, yes.
Oblige.
Oblige.
For the respondent.
Appearing for the petitioner, my lord. The petitioner is the wife. We have filed the petition seeking the transfer of divorce petition pending in Bangalore to Asan, my lord. My lord, I have also filed a petition, a civil miscellaneous petition for domestic violence, wherein interim maintenance was granted, my lord. The respondent stands in arrears from the date of order till now, my lord. I have filed a civil miscellaneous petition for execution of the interim maintenance also, my lord. The difficulty in traveling there is almost we have to cover a distance of 200 kilometers.
Any children?
Yes, my lord. One boy child, 8 years old.
8 years. Working?
No, my lord. As of now, she's not working.
Maintenance in which proceedings?
For domestic violence, no.
The maintenance in which proceedings?
Civil miscellaneous
miscellaneous?
514 of
miscellaneous
22.
proceedings, my lord.
514 of
Annexure-
22.
Yes, my lord. 514 of 2022. And order is at page number 31.
10,000 as per
Per
IA
month, my lord.
IA1, it's not being paid.
No, my lord. Till now, even a penny is not paid. We have filed another civil miscellaneous petition for execution, my lord. That is at annexure
Appeal
B,
is
my lord.
filed against, no.
Yes, my lord.
Appeal is filed against the order granting 10,000 per month or no?
No, my lord.
No, my
No,
lords.
please.
If I may make my submissions, my lord.
Yes.
My lords, I'm opposing this petition on 3-4 counts, my lord. Firstly, your lordship may kindly have a look at annexure A of my statement of objection, sorry, annexure R1 of my statement of objections, page number 8. To give your lordships a context, my lord, I had filed a divorce petition back in the year 2020 as a counterblast to the same and to pursue her motives with respect to this petition, my lord. After 2 years, she files the DV Act petition, my lord. The criminal petitions are filed in Hassan.
No,
After
that's-
2 years, my lords.
So now,
Your lordships may kindly
domestic
have,
no, domestic violence, forget.
your
Ignore those-
lordships may
Ignore
kindly
those
have,
proceedings. Come to
please,
the point.
your lordships annexure R1, my lords. I have a difficulty in this petition being transferred to Hassan for the reasons, my lord, that I have been threatened in the past.
My lord.
There,
No, just
sir, let
wait,
me
me
finish.
complete. Sit down,
Apologies.
sit down.
Your lordships, I submit that my wife's family is of influential background. This complaint that I had given back in the year 2020 has not been acted upon till date. Your lordships may kindly notice the second line in that complaint, my lord, annexure R1, page 8.
Yes.
ದಿನಾಂಕ 4th June 2020 ರಂದು ಹೆಂಡತಿ ಮತ್ತು ಮಗುವನ್ನು ನೋಡಲು ಬಂದಿದ್ದಾಗ ಹೆಂಡತಿಯ ತಮ್ಮ ಪ್ರಮೋದ್, ಅತ್ತೆ, ಮಾವ ಮತ್ತು ಇವರು ಗಲಾಟೆ ಮಾಡಿ ಹೊಡೆಯಲು ಪ್ರಯತ್ನಿಸಿದ್ದು, ಸದರಿಯವರುಗಳ ವಿರುದ್ಧ ಕ್ರಮ ಕೈಗೊಂಡು ನ್ಯಾಯ ದೊರಕಿಸಿದ್ದುಕೊಂಡು ಕೊಟ್ಟ ಅರ್ಜಿ. He has basically complained, my lord, that he is facing life threats when he has traveled to Hassan. Therefore, my lord, this is my major reason, my lords, that I don't want this petition to be transferred to Hassan, because I'll be faced with such threats time and again, my lord. I also, my lords, the family court herein has directed the petitioner herein to grant visitation rights. Your lordships may kindly come to page number 13, my lord. This order has been passed in the month of August. The Honorable Trial Court has reminded the petitioner time and again to grant me visiting rights to my only son, which has not been complied till date. Each first Saturday and each first and third Saturday, I appear in the family court. I put my signatures. My wife is not present before the family court. She doesn't comply with this order as well, my lords.
What is passed on?
16th of August, 2020, my lords. 2023, 16th of August, 2023. 6 months have lapsed, my lord. Your lordships will find it at page 30.
Why are you not paying maintenance?
Your lordships, firstly, my lords, my attendance in those matters is difficult, my lord. I have not been attending the proceedings regularly.
Why are you not paying maintenance?
Your lordships, I have to seek instructions as to how much maintenance is paid.
Find out. He
Till
says
date.
not 1 rupee is paid.
That is exactly why we
In
have
fact,
filed
my
this.
lord, I am ready to bear the
Execution, my
expenses of
No,
the
that we'll see.
wife's travel
No,
to Bangalore.
That's on merits. First, you pay maintenance, you give visitation rights. I'll fix it. Why are you not giving visitation rights?
Not to alticate. That is the difficulty I'm facing, my lord. To
Why?
come
What
from,
is the difficulty?
I have to travel 200 kilometers from
You
there,
have
my
to
lord. That is the first point. Second point is the.
So if you don't travel, I'm not going to consider your petition.
My lord, if the.
You can't keep away visitation rights. Totally
My lord,
unacceptable.
if the
Totally unacceptable.
the case is transferred, it will be easy for me.
I'm not
take
going
it
to
further.
consider your main prayer till visitation rights. You implement that order. Until you pay maintenance, I'm not going
Not
to.
considering
seek
that fact, even
instructions as to how
they are
much
not paying
maintenance
any
is paid,
maintenance
my
to
lord.
me, my lord.
I'll observe that.
Please.
I'll observe that. Both of you comply with the orders passed on IA number 4 and maintenance, and you come back. If you don't, I will see what is to be done.
Please, lords.
Realist the matter. 2 weeks on date code.
Date may be fixed.
14th. I'm
Great.
making it clear, don't play games with the child. Visitation right? Once the whether court passes or not, you must in letter and spirit give visitation rights, whatever may be.
But that is not
That is-
intentionally, I'm not.
That is between the parties, not between the child and the parent. Understand that. There may
But
be 101 things between both the spouses. It has nothing to do with the love and affection that the child is required to get from the parents. That you must understand.
I'll come fair
That's
before
a
your
great
lordship, my lord.
psychological game that you both are playing.
My lord, the
Don't use the child as a tool of
Make one
your
submission, my lord.
warfare between both of you.
I'll make only one submission, my lord. MC case was filed in the year 2020, my lord. Due to COVID restrictions, I made my appearance for the first time in 2021. After that, it was referred to the mediation, 2022. After that, I have failed to contest the case, my lord. I have not filed the objections. I'm not cross-examined anything.
Absolutely not, my lord. On the previous date, I was.
You can peruse the order sheet, my lord. It is
No, no,
clear from the
was
order sheet.
That is of
cross-examined.
no
That is the
relevance.
difficulty I'm facing
I'm
coming
asking
to
you a
Bangalore.
simple
my lord.
question. Why have you not shown the child to to the
My lord, I'm
father.
facing difficulty to come out
No.
to Bangalore.
You have to. What do you mean you are facing difficulty to show the
My lord,
child?
maintenance is pending from
That
almost
I've
1.5
asked her to,
years.
I'll see
ask them to
instructions
pay,
and
they
I'll-
will have it cleared by the next day. You do it and you also provide visitation rights as per the orders. I'm not passing fresh orders.
But,
Orders are passed which are on record. You cannot commit contempt of both of you.
Please, months.
Please.
Obliged.
We miss the matter next week, date. Good.
Lordship, I'm
Yes,
for petition, Your Lordship. This is a petition filed by the wife seeking for the transfer of the divorce petition filed by the respondent in Belgaum to Bangalore, Your Lordship. The petitioner, the wife, she's working, she's a software engineer, Your Lordship. She's working in Bangalore.
My lord, I'm for the respondent in this case.
yes, yes,
My
She's
lord,
working
we
in
are
Bangalore,
leaving
Your-
this,
yes.
my lord, we are leaving this to this court, my lord. Whatever the order the passed by this honorable court, we are obliged.
The petitioner. Wife has filed the present petition seeking for transfer of proceedings in MC 516 of 2023, pending on the file of the First Additional Principal Judge Family Court, Belgavi. After it is withdrawn, to be assigned to the Family Court at Bangalore. Full stop. There are no children out from the wedding. It is submitted that the petitioner and the respondent have entered into a matrimonial relationship on 17/2/2021. And after some time, differences have crept in and the respondent has initiated proceedings Where is the plaint?
No, Your Lordship, I have served only with the summons and I have not received the plain copy, Your Lordship. That was mentioned in the last date of hearing.
Has instituted proceedings in MC 518 of 2023. King, what is the relief you have sought for?
Divorce, my lord.
Dissolution of the matrimonial relationship, which case is pending before the Family Court at Belgavi. The petitioner submits that you are working.
Is Your Lordship.
Petitioner is working at Bangalore. And
Criminal miscellaneous petition is also pending, Your Lordship. Criminal miscellaneous petition is also pending.
and that traveling to attend proceedings at Belgavi, which involves travel of
507 kilometers.
507 kilometers, seriously interferes with her employment and inconveniences her. It is admitted that such distance cannot be traversed within one day, and accordingly, for every appearance before the court at Belgavi, the petitioner would lose out on 2 days of employment and may be required to stay overnight at Belgavi, which causes great inconvenience. Next. Taking note of the admitted facts that the petitioner is residing at Bangalore and that the court in which proceedings are pending at Belgavi is at a distance of about 500 kilometers. The assertion that petitioner may have to stay overnight if she has to attend proceedings at Belgavi requires acceptance. Next. It is also noticed that there are other proceedings pending between the parties at the court at Bangalore, including proceedings under the Protection of Women from Domestic Violence Act 2005 and Criminal Miscellaneous 258 of 2022. Accordingly, taking note of the distance of travel and that the petitioner is in employment, in light of the law laid down in M.V. Rekha's case is made out for allowing the petition, and accordingly, taking note of the convenience of the wife, the proceedings in MC 516 are withdrawn from the family court at Belgavi and directed to be transferred to the family court at Bangalore.
Yes, my lord, for the petitioner. My lord, this is the wife's petition. The wife is seeking for the transfer of divorce petition filed by the husband in Chikmagalur and for it to be transferred to Sakleshpur and to be clubbed with the maintenance case filed by the wife.
What is the distance?
Distance is around 70 kilometers, my lord.
70.
70. My lord, the marriage was solemnized
What is the
on,
difficulty then?
my lord,
travel 70
she's living with her parents and she is unemployed, my lord. And she has a child of below 5 years of age. And her parents are age old and it's difficult for her to travel with the child and also to look after her parents. And she has no income, my lord, and
50
she's
kilometers, what's the difficulty?
70 odd kilometers, my lord. And she apprehends being harassed by the husband.
Where have you
as well.
stated that?
My lord?
Where have you stated that?
Please, ma'am. My lord, page number 9 in the petition, para number 12.
The petitioner, in light of the apprehension of the petitioner made out at para 12 and taking note that the child born from within the wedlock is below the age of 5 years, there will be stay of further proceedings in MC 179 of 2023 till the next date. Emergent notice to the respondent. Petitioner is permitted to serve counsel for the respondent appearing in the trial proceeding. This is the matter week after next.
Please, my lord.
Petitioner in this case, no? Plus, the petitioner is the wife who sought for transfer of petition filed by the husband in Belgavi for restitution of conjugal rights. Now, the irony of the facts is, my lords, he is already married, and subsequent to his marriage and having a child with a illegitimate relationship, he has filed the case for restitution of conjugal rights in Belgavi. Now, both the petitioner and the respondent are working in Bangalore and
Both.
residing in Bangalore. Yes, my lords. But he has filed a case in Belgavi just to harass the petitioner. Moreover, they have a
But
son.
what is the, do you have anything to show? Is working at
Yes, my lord. I have, in the cost title, I have given his place of work, that Balistra Engineering Private Limited, next to Shell Petrol Bunk, Vasantnagar. That is the address he's working in, my lords.
in light of the contention that the respondent is working at Bangalore, though has filed petition before the family court at Belgavi. Subject to further consideration, there would be stay of further proceedings in MC 18 of 22 till the next date. Same order. But what has happened since 22?
22, now the evidence.
Started or?
Not yet started, my lords.
Yes,
Notice also.
yes.
Much.
Petition. I filed this petition, not seeking transfer in MC number 6 of 2014, my lord, and pending on the file of the principal fam.
From Chikmagalur.
Chikmagalur to Arsikere, my lord.
What is the distance?
My lord, more than 85 kilometers, my lord. She is also filed an criminal misdemeanor 380 of 2014.
What is the age?
She is, my lord,
Child.
child, my lord, she is pregnancy, my lord, 8 months pregnancy. Please.
In light of contention raised that the petitioner is conceived and that traveling to the port at Chikmagalur involves a travel of 80 kilometers, which inconveniences her in her present state of health. There would be stay of further proceedings and so till the next date. Please, same order.
Lord, we are seeking a transfer from Tirthalli to Davangere, my lord. The respondent has filed a MC.
What is the distance?
So 130 kilometer, my lord.
Huh?
130 kilometer, my lord.
130?
Kilometer, my lord.
130. What is the age of the child?
4 years, my lord.
4 years. Same, in light of the contention of the petitioner that petitioner is required to travel a distance of about 130 kilometers to attend proceedings in MC 5 of 24. 5 of 2024. $120 or $130 or $250?
130, my lord.
130 kilometers. And that from within the wedlock, she has a child aged about 4 years and traveling to attend proceedings seriously inconveniences her. There would be stay of the proceedings till the next date, same order. All matters which have not reached interim orders will stand extended by till the next date. Dates you can ask the court officer.
Last door, matter.
35 serial number, wherein I need an objection for the respondent.
The serial number 8.
You file it in the registry.
Last door, serial number 8.
You take a different date.